This is a non-contentious cause, my lord. Directions of publication of citations in the newspaper were passed by Honorable Justice Vibhas Patnaik in the month of September 2024. Accordingly, we had effected the publication, my lord. It was published in the respective newspapers as directed by the court on the 8th of December 2024. Thereafter, my lord, as per Lordship's solemn directions, my lord, the matter was directed to appear 8 weeks hence in anybody's, my lord, the determination whosoever the honorable judges would be taking it, my lord, from the date of publication of the citations. My lord, unfortunately, that has not come. The impediment is, my lord, the executor is an aged and an ailing person. Here, my lord, the will needs to be proven by the witness of, my lord, the attending witness, my lord, because the attesting witness also, my lord, have expired. So, my lord, therefore, that is what my urgency is, my lord. I was beseeching your lordship, any day convenient to your lordship, my lord.
No urgency. Next week the regular court will come.
My lord, kindly allows me, my lord, this chance, my lord.
Only the urgency matter. This court is already having a burden on so many matters.
My lord, it will hardly take, my lord,
I know, sir, but
more or less 15 minutes of your lordship's time, my lord.
Mentioned before the next court, the court will be start from next week, 24 onwards. So you take.
My lord, kindly allows this, my lord. I would humbly beseech you, my lord.
No.
My lord, at least allow me to hand over the mentioning slip, my lord.
Call the next.
Your Lordship, may I be permitted to mention a matter? This is an execution matter. Your Lordship had, on the last occasion, granted time extension to file an amendment application. It has been filed. The departmental scrutiny has also been done. I'm praying for inclusion, Your Lordship.
But may I be permitted to mention one matter? But item number 73 and 75.
73
and 75. My lord, this has been heard by Justice Patnaik. But the defendant has completed submission. Defendant has completed its submission. My lord, the plaintiff is in reply.
73 and 75.
My lord,
of the non-commercial matter.
Non-commercial.
Non-commercial.
Oh, commercial. My lord, sorry, my lord. Commercial matter, my lord. Lord, since my lord, Justice Patnaik has, my lord, substantially heard, my lord, but I am praying for, my lord, release of the matter to be assigned, my lord, before Justice Patnaik.
Go before the Chief Justice, assign.
We have written a letter, my lord, the office of the Chief Justice is saying, my lord, that an order of this honorable court is required.
Which matter? Item number?
73 and 75.
73 and?
75.
75. Record an order. As per the prayer made by the counsel for the, you are appearing for?
Plaintiff.
As per the prayer made by the counsel for the plaintiff, CS Com 578 of 2024, being within bracket old CS number 77 of 1981, is released from the list of the court. Same, the as per the prayer, CS Com released from this court. Yes.
Your Lordship may be permitted. Your Lordship may be permitted to mention item number 36 of today's non-commercial list, Your Lordship.
Today, non-commercial list?
Yes, Your Lordship. In this matter, this is a suit filed in 2021, Your Lordship. The defendants had filed a Section 8 application 2 years after the written statement was filed, Your Lordship. Mr. Rohit Banerjee was arguing that point. Your Lordship will keep it on any day. Fix a time.
Let the matter call. This is a commercial matter. Where is the other party?
We've mentioned. We are mentioning.
Today the matter is in the list.
Yes.
Let's come at after lunch. We'll see to that. It is reached. It's okay. No, it will not reach. Then you mention the matter.
Yes, Your Lordship.
In presence of the other party.
Grateful, Your Lordship. We are mentioning upon notice.
Okay.
For the plaintiff.
Worship, I appear for the defendant.
Amendment is allowed.
Obliged.
GA2 is disposed of.
Specific time is mentioned, my lord, if your lordship kindly some time frame, my lord.
The department is directed to carry out the proposed amendment within a period of 2 weeks from date. After the amendment is carried out by the defendant is directed to re-verify and reaffirm the written statement and to pay the requisite court fee within 2 weeks thereafter. The defendant is also directed to serve the copy of the amended written statement along with the counterclaim to the plaintiff. The plaintiff is at liberty to file written statement within 30 days from the date of receipt of the amended written statement along with the counterclaim.
Item number 2 is my suit, but I do not know why it has come for presentation. I'm not seeking any leave.
You have put the court number. That's why they
I'm sorry, my lord.
presentation form.
Oh, presentation. Oh, my lord, I'm so sorry.
Though the matter is listed under the heading presentation of plaint, but it is found that no leave has been paid for. Accordingly, matter be placed before the London Master for appropriate order.
Or your lordship may admit the plaint subject to scrutiny. That will take time. Lordship may admit the plaint subject to scrutiny.
Huh?
Lordship may admit the plaint subject to scrutiny. Again, otherwise we'll have to go to the
Recorded.
master.
Though the matter is listed as kya bola? So and so appearing for the plaintiff. The plaintiff has filed the suit praying for
The money claim, my lord.
praying for decree for an amount of rupees 3,37,40,888 along with interest at the rate of 18% per annum. Full stop. This court finds that the plaintiff has already initiated the pre-institution mediation process and non-starter report has been filed. Full stop. Plaint is admitted subject to scrutiny.
Grateful, my lord.
In this matter, my lord, I am appearing on behalf of the plaintiff. I have preferred this application of amendment to amend certain typographical mistakes in the plaint, your lordship. If your lordship kindly takes up my application, more
For the defendant have served.
no, your lordship.
Defendant not entered appearance.
No, your lordship. No, your lordship. If your lordship kindly come to the paragraph number 3 of my plaint.
Plaint.
No, your lordship. The
Plaint
more
or application.
the paragraph number 3 of my application, your lordship. It's more specifically mentioned in the page number 4, your lordship, which I'm seeking before your lordship. In the cause title of the plaint, after the word Odisha 756171, the following should be incorporated outside the jurisdiction of this honorable court. In the cause title of the plaint, after the word Kolkata 7,71,000, the following should be incorporated within the jurisdiction of this honorable court. In the annexure of paragraph number 13, after the word I, the word series is needed to be deleted. In the last line of paragraph number 16 of the plaint, and in the first line of its annexure, in page 7 of the plaint, the word reason is needed to be deleted. The paragraph number 19 of the plaint is needed to be deleted, and numbering of paragraphs thereafter are needed to be renumbered as paragraph number 19, 20, and 21 respectively. In the paragraph number 20 of the plaint, after the word non-starter report, the word reason is needed to be deleted. In the second line of prayer A of the plaint, after the word of, the following word rupees is needed to be deleted, your lordship.
Where is the paragraph 13 after the word I? Okay, I got it. And paragraph 16 of the plaint,
yes, your
first line of the annexure in page 7. What is that?
It's in the
last line of paragraph 16 of the plaint.
Yes, your lordship.
Of the plaint.
Yes, your lordship.
In the first line of the annexure, reason is to be deleted.
Yes, your lordship.
Okay.
And your lordship, along with that, I am craving for a leave to file a fresh statement of truth, your lordship.
Why?
The affidavit of the statement of truth was not according to the plaint, your lordship. So, your lordship, the concerned department just directed us to file a fresh statement of truth along with this amended plaint, your lordship.
So and so appearing for the plaintiff. The plaintiff has filed the present application being GA-Com 1 of 2025, paying for amendment in the plaint as appearing in paragraph 3 within bracket I2 Roman 7. Consider the submission made by the counsel for the plaintiff, perused the amendment as sought for by the plaintiff, This court finds that the amendment sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Counsel for the plaintiff also prayed for leave to file a fresh statement of truth by a fresh statement of truth. Consider the submission made by the counsel for the plaintiff. The amendment as proposed by the plaintiff in Annexer A, as well as filing statement of fresh statement of truth is allowed. Plaintiff is directed to list of the department is directed to amend the plaint amend the plaint as proposed in the proposed amendment within a period of 2 weeks from date. 2 weeks. The plaintiff is also directed to file the fresh statement of truth within a week from date. Full stop. After completion of
if your Lordship kindly grant us 2 weeks time to file this statement of truth, as my client just resides in the Odisha, your
2
Lordship.
weeks. GA Comp 1 of 2025 disposed.
I'm grateful to your Lordship.
This is that matter with the checkered history, my lord.
Yes.
Payment was to be made within 14 days from the last order.
That one.
Not made. Yesterday we received 1 crore.
That's right.
And we have been promised that we would be receiving 1 crore more today.
RTGS has already been initiated as of yesterday, my lord. I have the proof. It should be credited in my learned friend's client's account today.
Yes, but one. They were to pay 3 crores more within 30th of June. The other thing is, my lord, as per your lordship's order, I'm not claiming anything else. As per your lordship's order, interest is at the rate of 18%. So, my lord, what I was humbly beseeching that this today's 1 crore payment be adjusted on account of interest only. As on date,
Maybe.
only on account of interest at the rate of 18%.
My lord, but
I have prepared a chart. I'll hand off my learned friend a copy as well.
my lord, if the appropriation is towards the interest, then the interest will continue to mount. The principal will not be repaid.
Yes,
That is the
that is
difficulty.
if that is the whole purpose of interest, my lord.
My lord, the Contract Act also says that
And
the
we have-
person who makes the payment has the
My lord,
liberty of, my lord, appropriating the payment either towards the interest or to the principal.
my lord, my claim in the suit was 13 crores. I am not going on that. I'm only on that 8 crore, which was brought down. Your lordship's order provided for interest, and I'm going only on that basis.
Correct. The interest cannot become usurious, my lord. If it is credited towards the principal, then my liability does not grow because I am making the payment as per your lordship.
If it is outstanding, I have the right to adjust it against the principal. That is the right in Contract Act, which is provided to me under section.
Let us argue that out, my lord. For the time being, my lord, let it be recorded that I have made this payment.
Breach of undertaking possibly 10 times.
Yes.
Breach of affidavit, everything. Contempt of contempt.
For which I am facing the music.
Will not pay interest. চাইছি না।
কন্টিনিউ করবে কোর্ট আমরা কি করবো কি বুঝলাম
Copy of the report be
consequence will follow. You have a copy of the copy.
May I only indicate one thing, my lord? In the last day's order, that is, my lord, the order of 1st May 2025, at page 2, paragraph 5. Last day.
Due to financial
paragraph 5, my lord, we have given particulars of the properties that are available with the respondent numbers 2 and 4. My lord, here the larger patta numbers are given. So this description, my lord, actually exceeds the area provided. I have, my lord, prepared an affidavit with map, my lord, disclosing exactly the portions that are exclusively our assets.
No, that report has come from the collector.
In that case,
report has come from the collector. Which survey number you are harping upon?
My lord, if your lordship will see each of these survey numbers, for instance, 185 by 3 and 185 by 4, there are further subdivisions which exclusively belong to us. But if your lordship will see the area measurement, for instance, 185 by 3 and 185 by 4 together are supposed to measure, my lord, 45910 square
as per
feet.
the report of the collector,
Yes, my lord.
the 185 by 3 is having the extent of area 0.11.32.
Yes, so what I was trying to say, if your lordship will see, we prepared a schedule, my lord, I can hand it up.
0.11
Yes, that exactly that measuring. Exactly measuring that. Only what I was trying to say, my lord, is instead of 185 by 3, 185 3V. V for victory, that is what is exclusively
new
belong.
survey number.
Yes, that is all.
There, that is 3 capital V
That's
and
right.
185 4 H.
Yes,
Capital
that's right.
H.
So if
And that's the same thing. 174 9 is Y.
Yes.
And 10 is W.
That's right. So there are further subdivisions which exclusively belong to us. The areas are matching.
If you file a report, give the
please.
No problem. So what? So 1 crore you have received. So further amount you have sent.
My lord, further again 1 crore is
Keeps
to be
it- Kindly
credited. My
keeps
lord.
it in the first week of July because
Yes,
they're
till 30th June, lordship has
30th June they have time.
So today you are paying further amount.
Yesterday, my lord, 1 crore further has been remitted. It should hit my friend's account today. My lord, these exclusive properties, my lord, unless we are
Let them
allowed
further
to
pay
deal
the
with
3
some.
crores in the meantime, which they are supposed to pay by the 30th June. Because they were supposed to pay 2 crore initially within 14 days. 1 crore has already been received by us. 1 crore they have already remitted.
What I was beseeching your lordship to consider, my lord, is we have already indicated what properties exclusively belong to us, my lord. Now there is order restraining us from dealing with this. If your lordship permits us, my lord, to deal with it, keep it in a separate account, then we will be able to defray.
The amount be paid thereafter. I'll go away. I'll not be the thorn in his flesh. I'll go
In that case, my lord, if the injunction is confined to these properties identified in paragraph of my lord's last order, other properties that may be available with them, if they can deal with, otherwise, if they cannot liquidate any asset, they will not be able to, my lord, seize the money.
But kindly do not pass any order permitting them to deal with any of the properties.
My lord, the funds to pay my friend's dues, my lord, they have to be generated from somewhere. Properties of the company are already injuncted, my lord.
My lord, may I make one humble submission? Let them deal with the properties through a receiver, and the proceeds should come to us in to satisfaction of the decretal dues. I do not have any objection.
My lord, we are already paying them as per the undertaking given by the court, my lord.
Jodi sale through receiver properties to money to come to us.
These properties we have indicated in paragraph 5, my lord, these are completely unencumbered properties. We will not touch these properties. Aside from that, there are certain other assets. If we can deal with those, and
no problem. In that case, I am clarifying in the order. If you are dealing with the property, what are the dealing? You come with the dealing with an affidavit before this court. The amount of the dealing will be deposited. Then I will allow you to proceed with the matter.
Will be deposited in court.
Let me take instruction for 1 second, my lord.
Take instruction.
Lordship. We shall do that, my lord.
Because if you're dealing,
absolutely, my lord, absolutely fair suggestion, my lord.
Come with a memorandum with the person to whom you are selling.
Lordship.
Come with the memorandum here.
Before they deal with
it.
Before, yes.
With a memorandum with a supplementary affidavit or affidavit, whatever.
But let them make the payment which is due on the 30th.
Payment is then whatever the payment you deposit here, and I will allow to.
My lord.
If it's extra payment, you take you enjoy the payment. Extra payment.
But they had already given undertaking that by 30th of June they would be making 3 crore further payment. So this is possibly a tactic to not pay that.
2 crore by 15 days.
Yes. which is yet to come in
55
full.
days, shall pay the balance amount.
Yes.
With interest.
So that remains.
So
We
for
are
the
struggling
15
to
days is
generate
over,
those
but you have
funds,
not paid the
They have
2
not paid.
2 crore.
Every time there's a violation.
My
Well, there's not a
Lordship,
single day without
understand,
any
my lord,
violation.
the tremendous, my lord, financial strain they're laboring under. We are, my lord, straining, my lord, nerve and sinew to generate the funds to pay my learned friends' dues as per the undertakings given to your lordship's court. Now, my lord has provided a way. If we find a buyer, we will come to your lordship with intimation, take your lordship's blessings, and then, my lord.
Nobody talks to us.
My lord, if your lordship will kindly provide that liberty in the order, my lord, because the difficulty is, my lord, there are news broadcasts and flashes, my lord, in the jurisdiction, calling them cheats and things like that, my lord. Nobody will touch them with a barge pole. That is actually the difficulty.
So they could have been think about what would be the consequences if they are giving an undertaking before the court, that too in the High Court. Let this be clear first.
Lordship, can we hear this?
No.
This is
What?
broadcast and how he has been
What?
castrated.
My lord, if your lordship will permit, this is the news broadcast, etc. That is, my lord, giving people pause in dealing with them. That is the difficulty.
That is my lord's order that there should be a
Appearing for
direction on
the
the
petitioner.
registrar also.
So appearing for the alleged content number 2 and 4, and so appearing for the alleged content number 5, 6, 7, and 8. Full stop. Okay, just a minute. Yes, what is your application?
Number 1 of 2025 for modification of your lordship's order dated 6th of January 25, lordship.
But your lordship is taking up this application. Could it be on any other day, on Monday, Tuesday, any other day? Because we are not ready on that application, my lord.
No, what I am thinking with regard to now the total property has come on record with regard to the content number
Instead
2
of today,
to
Monday,
4.
my lord. Instead of today
2 to
on
4.
Monday.
Why they should be?
No, I understand, but instead of today, kindly take it up on Monday because this issue was going on.
Supposed to be listed on 13th of May. My learned friend said he's on vacation.
No problem. The court has indicated to Mr. Gupta what is in the mind of the court. Because once
To be very candid, we have not been ready with this because this issue was going on.
That's why.
No, I understand.
All the things has come on
I
record
understand.
through the competent
I
authority.
understand. Could we come back on Monday or Tuesday any day, my lord? Then?
So appearing for the petitioner, so appearing for the alleged content number 2 and 4, and so appearing for the 5, 6, 7, and 8. Full stop. Counsel for the petitioner submit that the petitioner has received an amount of ₹1 crore through RTGS.
Yes,
To RTGS from the alleged content number 4 or 2? 4. 2 and 4. From the alleged content number 4. Full stop. Counsel for the alleged content number 2 to 4, 2 and 4 submits that as per the order passed by this court dated 1st May 2025, the time for payment is up till 30th June 2025, and as such he prays for fixing the matter after 30th June 2025 so as to enable the alleged content number 2 and 4 to make further payment. What is the good name, sir? So appearing for the district collector of Tiruvallur, Tamil Nadu, and had filed report in compliance of the order passed by this court dated 1st May 2025 after serving the copy to the learned counsel for the petitioner. Let the said report be kept with the record. Full stop. Learned counsel for the alleged content number 2 and 4 submits that
1, 2, and 4.
2 and 4.
1,
2 and 4. Submit that due to the restraint order passed by this court, the alleged content number 1, 2, and 4 are not in a position to sell the property so that the amount which is due to be paid to the petitioner. क्या बोला? To be paid to the petitioner. Full stop. Counsel for the alleged content number 1, 2, and 4 prays for leave from this court to allow the alleged content number 1, 2, and 4 to sell some of the property so as to enable them to pay the balance amount to the petitioner. Consider the submission made by the counsel for the petitioner raised the objection and submits that if this court allowed the alleged contender to sell the property, the alleged contenders will not pay any amount to the petitioner. Heard the learned counsel for the respective parties. This court if the petitioner intend to sell any of the property to pay the amount to the petitioner from the sale proceed of the property in question, the petitioner, the alleged contender number 1, 2, and 4 shall come with an affidavit along with the proposed memorandum of proposed agreement, if any, entered between the parties, so that this court can peruse the transaction between the alleged contender 1, 2, and 4 and the proposed purchaser. And if this court satisfied that the alleged contender number 1, 2, and 4 can be allowed to sell the property, this court will pass appropriate order. In view of the above, the petitioner is given, the alleged contender number 1, 2, and 4 are given liberty only to entered into an agreement for sale, but that sale agreement will be confirmed by only by this court if this court is satisfied with the conditions, if any, and it is made clear that if any payment is received from the proposed purchaser, the amount is to be deposited in the register with the registrar of this court for realization of the due amount, and after the realization of the due amount along with the interest, the remaining amount will be released in favor of the petition, in favor of the alleged contender number 1, 2, and 4. The counsel for the alleged contender number 2, 5, 6, 7, and 8 prays for hearing of this GA number 1 of 2020. GA number 1
of
2025. But the learned counsel for the petitioner prays for a week time. In view of the submission made by the counsel, as per the prayer made by the counsel for the petitioner, hearing of GA 1 of 2025 is adjourned. Let the matter appear on. When you will be available?
Tuesday,
Appear on,
business permitting.
on
Or any other day.
19th of June 2025.
May I indicate one thing? I didn't want to interrupt, my lord. Your lordship will kindly see paragraph 7 of the order of 1st May, my lord, with regard to the timeline within which I am required to make the payment. Paragraph 7 says, my lord, counsel for the alleged contender numbers 2 and 4.
Yes, 15 days.
15 days, 2 crores, and then, my lord,
45 days.
And within 45 days thereafter, they shall pay the balance amount, my lord. So, my lord, we have put in 2 crores now.
Where 1 crore only you have put in.
One get further remitted yesterday, my lord. My friends will receive it today.
Yes.
Let it come. Let it come.
All I'm saying, my learned friends are saying by 30th June I have to pay the balance. My lord, we had said within 45 days of the initial payment. So some more time required.
If
That's
the
not
initial payment is delayed, that will also.
So I am fixing the matter on 27th. What is the progress with regard to the sale of the property? Let you come on that.
Let them at least make part payment.
Correct. In the
Let them at
meantime,
least
you
make
make
part
some
as
further.
we are doing.
I am fixing on 27th of June. 27th of June, I am fixing on.
Yes, ma'am.
Let us see what you are making the progress on that.
That
If you are
is
coming with an agreement on all these things, then accordingly I will pass appropriate order.
Absolutely.
Okay,
Only that
hearing.
lordship is recorded in the order by 30th June. We have to
Okay,
pay.
I
That
will
is
see to
contrary
that.
paragraph
You submitted, I will see to that. On 19th for hearing of GA1 of 2025. As regard the content application be placed on 27 June 2025 for further order.
My lord, my instructing advocate says he will not be available on the 27th. I will not be able to handle without him. On the 26th, I am requesting subject to your lordship.
26 come on 26.
Great. Well, you may be given to file everything.
Lordship, I am appearing for the defendant in this.
I am for the plaintiff in this matter. I am for the plaintiff. I am plaintiff in this matter. The inspection and discovery would not be completed yet. So, but we have received the documents from the client. So that if Lordship grants me 2 weeks time, we'll complete the inspection and discovery and come back with our issues.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff submit that as in terms of the order on the as per the order dated 24th April 2025, the discovery and inspection of the document could not be completed and placed for further 2 weeks time. In view of the submission made by the counsel for the plaintiff, time to complete the discovery and inspection of the document and filing affidavit of admission and denial of the document is extended for a further period of 2 weeks. In the meantime, all the parties are also directed to exchange the suggested issues. List the matter on 26th June 2025 for framing of issues. Yes. Number 8. It will be done on 26th.
Yes, no problem.
My lord,
Next.
In item number 8, my lord, I am appearing for HDFC Bank Limited, defendant number 3, my lord.
Yes.
My lord, I am appearing for IndusInd Bank Limited, the defendant number 4, your lord.
I am appearing on the State Bank.
Who is for the plaintiff? Who is for the plaintiff?
Mr. Mishra was probably appearing for the plaintiff.
Last occasion also none appears for the plaintiff. Devanand Mishra. What is the application? GACOM, who has filed this application?
My lord, I have filed this application.
Or?
My lord, in this matter, there was an order for ex parte hearing against my client. And I'm praying for a condonation of delay and in filing this application and also for recalling of that order, my lord. It is a completely advocate's failure. First, the earlier advocate had not appeared, and thereafter, when I was appointed, my lord, I suffered from chikungunya and could not appear in court for a very, very long time. Therefore, the delay in filing the application, but the order was passed because the earlier advocate who had been appointed had not appeared in court and had thus the order for ex parte had been filed, my lord.
But when you have received the writ of summons, madam?
In 2017, my lord.
How if at all the order is recalled, how you have been allowed to file the written statement after 120 days? It is a commercial matter. I will dispose of this application, be giving a liberty to cross-examine. You can cross-examine the witness.
Very well, your lordship. Very well. I bow down before your lordship.
Yes, and who is the other?
My lord, I am appearing, my lord, for HDFC Bank Limited. My application is GA4, my lord. We had filed an application, my lord, under Order 7, Rule 11 of the Code of Civil Procedure, my lord, on the ground that the suit is barred by law. My lord, one thing I would like to bring to your lordship's notice. On the last occasion, my lord, when the plaintiff had appeared, the plaintiff had handed over a copy of the order passed by the Honorable NCLT, my lord, wherein, my lord, the plaintiff company, my lord, has been sent to CIRP. So, my lord, at present, my lord, corporate insolvency resolution process is going on, my lord, in respect of the plaintiff company.
That's why the plaintiff is not appearing. So, I am dismissing the suit.
My lord, the order is order dated November 14, 2024, passed by NCLT.
But nobody is there. There is no order here. None appears on behalf of the plaintiff. You are appearing for defendant number?
3, my lord, HDFC Bank Limited.
Appearing for the defendant number 3 and appearing for. Madam, you are appearing for?
For defendant number 4, IndusInd Bank Limited.
Number 4. Full stop. It is fine from the record that the matter was fixed on 7th of March 2025. On the said date also none appears on behalf of the plaintiff. Today also when the matter is called, none appears on behalf of the plaintiff. No accommodation is sought for. Accordingly, no accommodation is sought for. Full stop. This could find that the plaintiff is not interested to proceed with the matter. Accordingly, CS Com 5 of 745 2024 is dismissed for default. Interim order, if any, stand vacated. Full stop. Consequently, all connected application also disposed of. Next.
I'm grateful, Your Lordship.
But here, my lord, I am for the plaintiff, my lord. My lord, direction was there, my lord, to complete, my lord, discovery and inspection, my lord. My lord, plaintiff has disclosed its documents, my lord. The inspection taken by my learned friend, my lord. Thereafter, my lord, we went to, my lord, take inspection of their documents, my lord. But we did not have the documents with us, so that is still pending, my lord. Lordship kindly grants me, my lord, 2 weeks time, 3 weeks time, my lord. I shall take inspection of the documents, my lord, and thereafter, my lord, admission and denial of documents will be filed with it.
Since February.
Yes, my lord, we have already given. We had number of.
Yes, since
My
February.
lord, I am for the defendant, my lord. Grant some time. I think in the next date everything will be complete.
13th March
November
was
24.
Yes,
Further time shall be not be allowed. Inspection and document.
Thereafter, 13th March.
Correct. 21st November. No further time.
Yes, my lord. There has
Thereafter,
been a delay, my lord.
case adjourned. I am dismissing this. 7th February.
We had.
But you are not interested to proceed.
No, my lord. That would be yes.
I am dismissing it.
Kindly, my lord.
One year has been passed.
No, I understand, my lord. Please.
There was some
Sorry, 2 weeks, my lord. Please grant 2
grant
weeks.
us 2 weeks.
2
We
weeks.
have given
Everything will be
our
complete.
documents, my lord. Only we have to take inspection of the defendant's documents. That is it, my lord.
Just 2 weeks, my
lord.
So and so suffering for the plaintiff. So and so suffering for the defendant. This court find counsel for the plaintiff submit that the plaintiff has already inspected the document of the defendant, but the plaintiff could not disclose their document to the defendant.
No, my lord.
We have disclosed our documents. Defendant has taken inspection of plaintiff's document. We could not take inspection of the defendant's document because they served it later.
Counsel for the plaintiff submit that. No, plaintiff has disclosed their document to the defendant, and you have completed.
We have also given we have also disclosed the document.
Defendant has also disclosed their document to the plaintiff, but inspection could not be completed. This court find that discovery and inspection of the document is pending since the month of July 2024, but till date both parties failed to complete the discovery and inspection. Today also, when the matter is called, both the parties press for extension of time to complete the discovery and inspection. For the interest of justice and as a matter of last chance, time to complete the discovery and inspection of the document is extended for a further period of 2 weeks.
27th, my lord.
2 weeks. In the meantime, the parties are also directed to exchange their suggested in 2 weeks. On completion of discovery and inspection, the parties are directed to file their affidavit of admission and denial of document within 2 weeks thereafter. In the meantime, the parties are also directed to exchange their suggested issues. Let the matter appear on 15th of July 2025 for framing of issues. It is made clear that by the date fixed, if the parties fail to complete the discovery and inspection as directed above, chance to complete the discovery and inspection will be closed and the case will be proceeded accordingly.
So grateful, lordship.
One more indulgence, my lord. Pendants, this was filed in the regular division, my lord. Thereafter, it was transferred to the commercial division, my lord. We had filed the vakalatnama and competency there, my lord. But my lord, I understand from the department, my lord, the department has returned this and has said that it has to be filed with the plaint, and the plaint is before your lordship, my lord. So it could be filed here, my lord. The vakalatnama and the affidavit of competency has to be filed. It has to be filed.
I am giving liberty to file in the department subject.
It was already filed in the department. They returned it because the plaint is before your lordship, and I have to file it here.
The vakalatnama and affidavit of competency filed by the plaintiff be kept with the record.
Grateful.
Affidavit of competency.
Affidavit of competency.
Competency.
Vakalatnama and affidavit of competency.
That's why.
Yes.
Grateful. We're extremely grateful.
Lordship, I'm for the defendant. Lordship, I'm appearing for the plaintiff. As per the last order, we were
24th.
30th. No,
30th.
30th April. 30th April.
The case is to be listed on 24th of June.
Yes, Lordship, for framing
Number
of issue.
24.
But Lordship, this was for discovery and inspection. Although we have written a letter to them,
We
but
have replied, Your Lordship. We have replied.
Lordship, we have not got this.
We have replied. We have asked for discovery. See, Lordship would see this.
We have not received. If I could just check the mail ID, we have written. We were under the impression that we have not received any reply.
Yes, not. Both are given the letter but not complied with.
Lordship may kindly extend it. And if I could just check the email ID in which it was sent.
Census appearing for the plaintiff, census appearing for the defendant. By an order dated 30th April 2025, this court has passed direction for complete the discovery and inspection of the document and filing affidavit of admission in any document, as well as exchange of suggested issues. And the matter is directed to be listed on 24th of June 2025 for framing of issues, but inadvertently matter is listed today. When the matter is called today, learned counsel for the respective parties shown their communication, informing the parties, informing each other for disclosure of the document, but the parties have not disclosed their document to each other. But the parties have not disclosed their document for inspection and press for extension of time. In view of the submission made by the counsel for the parties, the plaintiff is directed to disclose their document to the plaintiff on or before 26th of June 2025. Simultaneously, the defendant shall also disclose their document to the plaintiff by 26th of June 2025. After disclosure of the document, both the parties shall complete the inspection of the documents by 8th of July 2025. After completion of the discovery and inspection, the parties are directed to file their affidavit of admission and denial the document by 14th of July 2025. And the parties are also directed to exchange their suggested issues. List the matter on 18th of July 2025 for framing of issues. ये दे दो उनको लेटर. Next.
Well, I am for the plaintiff, my lord. In this matter, my lord, two cross appeals are pending before Justice Arijit Banerjee and Justice Omnara Rai.
What?
My lord, two appeals, one preferred by the plaintiff and one preferred by the defendant. Both appeals are pending before Justice the Honorable Division Bench, my lord. In
the meantime, I am for the defendant. In the meantime, the parties are also trying to
settle
outside
the issue.
the court. So we both the parties are out. Means my client is in Delhi. It's a media house, the TV Today group, and they are the phonographic performance.
Maharaj,
So there are multiple litigations across the country, in Bombay, Delhi, everywhere. So it's a cumulative settlement which they are looking forward. So if it can be taken up sometime in August or the monthly list of August.
So appearing for the plaintiff, so appearing for the defendant. It is submitted that both the parties have preferred an appeal, and the same is pending before the appellate court. It is further informed by the learned counsel for the respective parties that the parties are trying to settle the issue. In view of the counsel for the parties press for fixing the matter in the month of August 2025. In view of the submission made by the counsel for the respective parties, let the matter appear on 21st of August 2025.
Lord, I appear for the plaintiff. Now, there's an innocuous prayer. I understand the department must have sent a report also to your lordship. Lord, if your lordship takes your lordship's order of 4th March 2025, Lord, there were some corrections that were required to be made in the affidavit portion in the plaint, which your lordship allowed and permitted us to reaffirm and re-verify the plaint. But there were no directions for issuance of writ of summons, and hence the department is not issuing the writ of summons. They've said unless your lordship gives that.
When you file the affidavit,
this is the last order of your lordship.
That is there. When you file the affidavit, verify and reaffirm the affidavit.
10th of March we reaffirmed and re-verified.
Then 3 months already passed.
They're not.
You could have filed an
repeated times.
Have you filed an application before the master? Then
My lord, they said that they will be sending the file to your lordship, and your lordship
this
once
report आया क्या?
they said they'll be sending a report also. That's why exactly
Report is not there.
they
Without the report,
Lord,
how
on
the court
instructions
can
I'm
without
saying
app-
they said that they've sent the report to your lordship. We can go to the department again if that is
No. No such report.
Lord, then in that event, my lord, if your lordship keeps it next week, my lord, we'll see whatever is there and then come back to your lordship. If required, we'll file an application.
Without application, it
If required, we'll file an application.
As per the prayer made by the counsel for the so-and-so suffering for the plaintiff. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 20 June.
Deeply.
Item number? हाँ हाँ कहाँ गया वो? नहीं बताओ वो सब क्या है? वो क्या है? अभी ऑर्डर किसमें किया? हाँ आइटम नंबर 11. अच्छा 11. तो उसको तो फिर अमेंडमेंट भी करना था. कहाँ हुआ? Item number 11 में ऑर्डर करो. It is found that the matter is transferred from the non-commercial from the ordinary original civil jurisdiction to commercial division, and the department has carried out the amendment, but no commercial suit number has been assigned. Accordingly, department is directed to assign the new commercial number in CS number 135/2000. क्या नंबर क्या है? CS है, TS है, क्या है? फिर TS क्या है? of CS number 135/2013.
Yes. My lord, I appear for the plaintiff in this matter. My lord, suit for money instituted in the year 2017. Lord, in 2023, the matter was transferred from the non-commercial division to the commercial division. Lord, I've taken out this application seeking leave of this honorable court to disclose additional documents. My lord, pleadings are complete in the matter. My lord, I'm led by Mr. Rupa Ghosh. My lord, he's in some difficulty. So I was humbly praying if your lordship could fix any date for hearing of this application.
My lord, only one, my lord, I will not come in the way of Mr. Ghosh's ground. My lord, only one thing, my lord, kindly look at the application and the prayer, my lord. The prayer says, my lord,
you granted to plead and disclose and rely upon the documents.
At para 9. Now, my lord, kindly takes para 9 at page 4.
Called for a conference of the looking original document during the course of discussion. It was revealed that the
Now, the schedule
forming the part of
schedule is at page 12, my lord. Will kindly take page 12. Now, this is the list of documents, my lord. Now, my lord, when the matter appeared before another coordinate bench, my lord, I appeared and said, what are these documents? We should have a look at these documents.
Where is the document?
They gave us a pen drive. Now, this pen drive has around 1,500 pages. No, more than that. So those documents have to be brought on record, because ultimately, if the court allows, how will we match whether these documents which the court has allowed has in fact been disclosed? So those have to be brought on record, no matter how voluminous they are.
My lord, my instructions are that the documents we seek to disclose, my lord, are very voluminous. My lord, in order to ascertain that, my lord, we have given them a soft copy.
But how the court can ascertain?
Lord,
You are not disclosed here. Tomorrow, January 14 to April, what is the total number? You have not mentioned. Suppose this court allowed, and tomorrow you started the evidence, and you are producing some document. He is objecting that this document was not allowed. How it will be proved?
Have to be brought on record.
Lord, this will, Lord, as per the commercial code's complaint, Lord, this will form the part of my affidavit of documents. My lord, they will take their admission denial on that.
What? As per the commercial, only a list will suffice.
Lord, I'm submitting all the documents, my lord.
So
I shall.
That bring the document. What the document will rely on? Maybe you have submitted. How the court will ascertain what document?
And they can show me one document disclose something else subsequently.
The serial number of the document.
In that case, my lord, will kindly adjourn the matter today, my lord. Kindly give me time. I shall come back in the next week, my lord. I'm led by Mr.
They can take a leave and file a supplementary affidavit.
Correct. Because document court has to see. Court cannot see only the list of document. Court has to see what the document you relied upon.
I will not come in the way, but the document should be on record.
Opening for the plaintiff, opening for the defendant. Plaintiff has filed an application being GA Com 3 of 2024, praying for allowing the plaintiff to disclose additional document. To disclose documents as referred in Annexure D, page 12 of the present application. Counsel for the defendant raise objection and submit that the defendant has not disclosed the document which they are relying upon. Only the description of the document has been mentioned in Annexure D. And as such, without the document, this application cannot be allowed. Counsel for the plaintiff prays for time for taking appropriate steps. Accordingly, case is adjourned. Let the matter appear on 8th of July 2025.
Very well.
Grateful.
In this matter, I'm appearing for the plaintiff, my lord. The suit was filed in the non-commercial division. Subsequently, it was transferred to the commercial division. My lord, we'll see the last order, my lord. The plaintiff had filed the statement of truth on the list of documents, but my lord, the defendant had not. So, my lord, it was directed that the subsequent provisions be complied with, my lord. The order of 13th of March 2025.
Yes.
My lord, my statement of...
You are for the plaintiff.
I am for the plaintiff. My statement of truth and list of documents are on record, my lord.
Yes.
Although it does not record here, but my lord will find it in the... Okay,
what?
In
Statement and truth?
Yes, my lord. देखो. Found the statement of truth on the list of documents.
Yes.
So that's why on behalf of the plaintiff, my lord. My lord, record set today because it's not mentioned in the order of 13th March. And defendants are not appearing, my lord.
What about the defendants?
They appeared on the last occasion, my lord. We'll see on 13th of March they were appearing. My lord, we can give a notice upon them if my lord so directs.
So this is yours?
Yes, my lord. Plaintiffs on behalf of the plaintiff, my lord.
So appearing for the plaintiff. None appears on behalf of the defendant. Defendant has already and the plaintiff has already filed a statement of truth and list of document under order 11 rule 1 within bracket 2 of the Code of Civil Procedure as amended under Commercial Court Act 2015. Full stop. None appears on behalf of the defendant. No accommodation is sought for and no steps has been taken for complying with the provisions of the Commercial Court Act. For the interest of justice, the case is adjourned. Let the matter appear on 10th of July 2025. The plaintiff is directed to inform the next date of hearing to the London advocate on record of the defendant.
And liberty be given to my lord forward a copy of the order to pass today, my
lord. And also to forward the copy of this order for information of the defendant.
I'm extremely grateful to my lord.
After your lordship admonished us on the last occasion, we have got the certificates from the department. After your lordship admonished us on the last occasion, we have got the certificates from the department.
Thank you.
There are 3 suits, 28, 29 and CS 28 of 2018, 29 and 30. Now here, the original defendant number 1 was a UK based company. That company went into liquidation as per the UK Insolvency Act. So, my lord, we had got the liquidators appointed in respect of that company, substituted, my lord, in place of the original defendant. Thereafter, we had attempted to serve. Kindly seize the sheriff's report, my lord. Defendant numbers 1A and 1B are the liquidators, joint liquidators.
Item delivery confirmed on 29/9/2022.
For 1B, tracking report is not available on 1A.
Is not available for 1A.
1A.
Who is 1A?
These 2 are the joint liquidators.
Liquidators. Yes. Okay.
And identical remarks in respect of, my lord? No, not others.
29 also?
No.
Item delivered?
No.
Confirmed
29 and 30.
1A and 1B. 29?
30 identical, which is 1A and 1B. 28 is only 1A.
1A and 1B, yes.
Kindly see, in the other two, it's on 1A, 1B.
So, but all are same person.
Same parties, same company. The original defendant number one is the same. The plaintiff is different. In three matters, the different plaintiffs. But in other two, I find that it's delivered on 1A and 1B. But in this one, it's only 1A.
That to 2022.
Yes, that to 2022. It was dispatched. No, yes. (29) and 30, your lordship would find identical remarks. 1A and 1B both received.
What will happen to the 28? 1B?
But they are joint liquidated. So, my lord, service on one should suffice, my lord. But the other defendants have already filed a written statement. Possibly they should go ex parte against the.
Who is appearing for the other defendant?
Mr. Arnab Shordar is the advocate on record, and Mr. Rachit Lakmani had.
Milord, I represent. Milord.
Yes.
I represent.
Already filed the written statement.
I'm sorry there physically today before your lordship.
You filed the written statement, yes. Mr. Lakhani?
Yes, my lord. Long back, in fact, there is an order, my lord, of a coordinate bench which says that the plaintiffs will not have a claim against me in this suit.
Suffering for the...
I'll place the order. We moved the demurrer, my lord, this order was passed.
No, there is nothing.
For the defendant number 2.
And my lord, also my name has changed. Mr. Gupta would know, my lord, I'm Credit Suisse. My name has now changed, so they will have to take some steps.
You take out a substitution for the other defendant.
Defendant number 2, what is the name?
Credit Suisse. Now it has changed.
What about the 3?
Not appeared.
3 had never appeared.
Never appeared. Butcher and Wiles. And Credit Suisse.
Credit Suisse. That name has changed.
That name is changed. And 3, where is the report? There's any order against the undefended?
No.
Any report?
We have not received.
Then what can be done? This is also Switzerland. Suffering for the plaintiff. Suffering for the defendant number 2. Counsel for the defendant number 2 submit that name of the defendant number 2 is changed, but the plaintiff has not taken any steps for correction in the name of the defendant number 2. Counsel for the plaintiff prays for time for taking appropriate step for correction of the name of the defendant number 2. Plaintiff has handed over the service report, has submitted the service report with respect of the defendant number 1A and 1B. It is fine that it is fine from the service report issued by the Deputy Sheriff of Calcutta. Delivery of the item is confirmed upon the defendant number 1B, but no tracking report is available with respect of defendant number 1A. Counsel for the plaintiff submit that both are the joint liquidator, and as such, joint liquidator, and in other matters, in the same address, the notice have been received by the defendant number 1B. 1A, and as such, he prays for fixing the matter as undefended against the defendant number 1A and 1B. Consider the submission made by the counsel for the plaintiff and the report and the service report dated 13th May 2025 issued by the Deputy Sheriff of Calcutta. Let the matter be placed in the list of undefended against the defendant number 1A and 1B. 1A and 1B. Full stop. The counsel for the plaintiff prays for time to obtain report from the defendant number 3.
3 and 4. CS20, CS28 has 3. 29 has 3 and 4.
Counsel for the plaintiff prays for time to obtain report from the department with regard to service of notice upon the defendant number 3. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 17 July 2025. ठीक है, इसी तरह होगा आइटम नंबर
CS 20.
16. 16, how many defendants?
But some order would change because here your lordship recorded the tracking report is not available. So that
Record item number 70. 16. Census. There also Mr. Lakhani is there.
Yes.
Census appearing for the plaintiff. Census appearing for the defendant.
Yes, my lord, in all three matters, 15, 16, 17.
Defendant number 2. The plaintiff has filed the service report wherein it reveals that the notice have been served upon the defendant number 1A and 1B on 29th of September 2022, but in spite of service of notice, none appears on behalf of the defendant number 1A and 1B. Accordingly, the suit be placed in the list of undefended suit against the defendant number 1A and 1B. As regards service upon the defendant number 3 and 4, counsel for the plaintiff prays for time to take report from the department to ascertain whether the notice is served upon the defendant number 3 and 4. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear. Date the other 17, na? 17 August July 2025.
same order may be passed in the next one. Only that there is defendant number 3 only.
Item number same. Item number 17.
17.
Census offering for the plaintiff. Census offering for the defendant number 2. Plaintiff has filed this service report issued by the Deputy Surveyor of Calcutta, wherein it reveals that writ of summons have been served upon the defendant number 1A and 1B on 29/9/2022, but in spite of service of notice, none appears on behalf of the defendant number 1A and 1B. Accordingly, this should be placed in the list of undefended suit against the defendant number 1A and 1B. Counsel for the plaintiff prays for time to take steps to ascertain whether the notice is served upon the defendant number 3. According case is adjourned, let the matter appear on 17 July.
Grateful, my lord.
This matter will go on for some time.
No.
Oh.
Just start. My lord, I am for the respondent, my lord. This is, my lord, that section 34, my lord, which we were opposing.
My lord, there are 2 or 3 things that, my lord,
To really start the matter, my lord, according to me.
No, my lord, my learned friend is very insistent
If
that, my lord, all the other, my lord, difficulties that have arisen in the matter should be completely bypassed. I'll tell your lordship what happened. My lord, to be very, my lord, candid with the court. My lord, your lordship had heard the 36-2 matter. My lord, lordship has, my lord, formed certain opinions, and my lord, there we addressed your lordships on, my lord, the entire merits of the matter. Because, my lord, in the course of addressing your lordship on the question of whether there was fraud or corruption, my lord, all the matters, including Amrit Vanaspati and, my lord, the bar of law, that had been, my lord, argued. Now, my lord, your lordship was pleased to, my lord, observe that there's no fraud and corruption, and, my lord, put us to terms that, my lord, we should secure. So in terms of your lordship's order, my lord, security could not be furnished because lordship had furnished, directed part cash, part ban guarantee. My learned friends proceeded in execution. Well,
They went up to the Honorable Supreme Court. Supreme Court dismissed the special leave petition. Review also dismissed.
That's right.
We proceeded in execution.
My learned friends proceeded in execution. So, my lord, your lordship's order, my lord, in 36-2 was upheld. My lord, in the execution court, my lord, an application was filed. My lord, there are 2 entities. My lord, one is the government of West Bengal, one is the West Bengal Industrial Development Corporation. My lord, the government is represented by the Advocate General. My lord, the government filed an application under section 47. My lord, and said that, my lord, this cannot be executable. My lord, the order is a nullity or the award is a nullity. Not the order, the award is a nullity. And hence the award cannot be executed. That section 47, my lord, as I addressed your lordship, is being argued in the next court. My lord, that matter is now going on. And, my lord, there were...
This matter will appear before the same...
Well, I'll tell you, lordship, my lord, let me...
Section 34, my lord, according to me, my lord, if they are... Because that's, my lord, the substantive, my lord, ground on which they have challenged.
Let me, my lord, finish my...
This is an assigned matter.
I'll tell you, lordship. Now, my lord, in the, my lord, execution application, there was initially an order made by the executing court. Against that, my learned friend, my lord, went up before the Supreme Court once again. My lord, one of the questions that arose before the Supreme Court, my lord, as I'm instructed by the Advocate General who was appearing personally, I find Mr. Banerjee was also there. My lord, one of the questions that arose, my lord, whether the matter should be heard, my lord, by the same court, but the 2 matters should be heard, 34 and the execution, because the questions will be the same. Well, at same court. My lord, may I just hand up to your lordship a copy of the order of the Supreme Court?
No question. I'm sorry, I was there. Personally, I was there.
No, I was not there, my lord. I shall only
speak
to
the prayer was made on their part. The Honorable...
let me just show you, lordship,
the Honorable Supreme
Court order, since I was not there.
Yes.
Well, let me just speak to the order.
Order
Please
doesn't
come
say
to, my lord. the paragraph, the third page of the order.
Yes.
My lord, we are informed that so far as paragraph 8, we are informed that so far as section 34 proceedings are concerned, it is before a different court. For the present, we are not saying anything so far as 34 proceedings are concerned. Now, my lord, after that, my lord, the observation that was made orally, I understand from the correspondence exchange between the parties, was that, my lord, you mentioned before the Chief Justice so that the matters can be assigned before the same court. Now, my lord, may I show your lordship, my lord, a letter that was written, my lord, in this regard to the Secretary of the Honorable Chief Justice, my lord, requesting, my lord, that, my lord, the matter be assigned. And, my lord, we had said that, my lord, it should be, my lord, before the executing court. And, my lord, we had said very specifically that, my lord, at page 2, paragraph Roman 5. During the hearing on 19th May 2025, Government of West Bengal and WBIDC had apprised the Honorable Supreme Court that while execution application and Section 47 application are pending before the execution court, the Section 34 proceeding petition is pending before a different court. Government of West Bengal and WBIDC had accordingly prayed that the Section 34 petition 2 should be listed before the execution court. Honorable Supreme Court had orally indicated that Section 34 petition 2 should be before the execution court. However, it observed that it would be for the present there would be for the present no record. Not record anything further, and since the learned Advocate General for the state was present in court, Honorable Supreme Court was verbally desirous that the Advocate General may mention the matter for the Honorable Chief Justice for assignment of the Section 34. Accordingly, my lord, notice was given. Now, my lord, there's a response to this notice. My lord, may I hand up the response that my learned friends have given to this notice of mention? My lord, please come to the second page. Well, please come to the third page, paragraph 8. Well, this is what my paragraph, the second page, last paragraph. Well, my learned friends reproduce the portion of the Supreme Court order which says that for the present we are not giving any direction. We are not present saying anything so far as 34 proceedings are concerned. Then, next paragraph. There was no direction given by the Honorable Supreme Court as to transferring the Section 34 application from the present bench to the bench hearing execution application. However, an oral observation was made that a request could be made to the Honorable Chief Justice that both the Section 34 application and execution application could be heard by the same bench. The contention in the said letter that the Honorable Supreme Court orally or otherwise indicated that the Section 34 application should be before the execution court is incorrect and contrary to record. The said contention made on behalf of GOWB and WBH is most unfortunate. But, my lord, what is accepted is the fact that the, my lord, Supreme Court had observed that, my lord, they should be heard by the same bench. We had, my lord, given a letter to mention the matter before the Chief Justice. My lord, the Chief Justice did not sit yesterday. So, my lord, the matter could not be mentioned. We have, my lord, given once again a letter for mentioning as soon as the Chief Justice, my lord, takes up the matter. In the meantime, of course, we have also, my lord, prepared a rejoinder to the reply filed in the Section 34 application by my learned friends, my lord, which I would, my lord, request your lordships leave to file. My lord, the Section 47 is now being heard. That touches, my lord, directly on the, my lord, executability of the award. My lord, the question of, my lord, whether the matter should be heard by, my lord, the same learned single judge or by two different benches, my lord, that will have to await the Chief Justice's consideration. All that I'm saying, my lord, in all fairness, my lord, and my lord, this is, my lord, the submission I make strictly on instructions. It is not my personal view. My lord, since your lordship has, my lord, had occasion to go through the entire, my lord, set of arguments in the matter and to form an opinion, whatever the opinion may be. My lord, 36 is, of course, independent of 34. 34, my lord, will be on a totally independent constitution. But since your lordship has made observations, my lord, touching all these questions, my lord, in the 36-2 matter, well, it is possible that, my lord, your lordships have already formed a view in the 34 matter. It is possible, my lord, it is, my lord, of course, we will always have a chance to independently address your lordship, but, my lord, your lordships has formed an opinion and expressed it in a judgment. But it is for these reasons, my lord, that there are, my lord, certain apprehensions that, my lord, your lordship, my lord, ultimately will be confined to the opinion that your lordship has already formed. It's not a question of bias, my lord. Let me make it very, very clear.
Okay, no problem, no problem.
My lord, and, my lord, that is, my lord, the reason why much this submission was made before the Supreme Court. This matter came up before the Supreme Court, and the Supreme Court said, yes, both should be heard. Even according to my learned friends, both matters should be heard by the same learned bench.
Before this court?
Yes, yes, whether before this court.
No, this court. Well,
sorry, now, my lord. Now, my lord.
I'm very aggrieved by your submission.
No, my lord. My learned friend.
I'm sorry, I'm very aggrieved and I'm very unfortunate. I reiterate what has been stated in this letter.
Now, my lord, my learned friends insisted that, my lord, the execution application be taken on, the Section 47 be proceeded with before the execution court now.
No, not Section 47.
And, my lord, it is now proceeding before the next court in the next room. The Advocate General is engaged there. So, my lord, now my learned friend says that no, well, the section, my lord, execution application should also come before lordship, my lord. That is, my lord, contrary to, my lord, his conduct before the court this morning. So, my lord, therefore, there is no question of, my lord, now The execution application
Mr.
we
Shah,
brought before your
I
lordship.
did not insist that your execution should. Well, now, may I make my submission?
My lord, in any
Well, this
event, my lord,
matter.
what I am saying is, my lord, let it await, my lord. Let us place the matter before the Chief Justice. Well, let us await, my lord, the Chief Justice's direction in this regard.
Okay, let
Yes.
me hear the Mr.
Well,
Banerjee.
this is a Section 34 application where the question of whether the award should be set aside, substantial questions have to be decided here in terms of Section 34. The matter, my lord, is specially assigned before my lord, both Section 34 and so was the Section 36(2) originally. In the Section 36(2), my lord considered one aspect of the matter because they wanted unconditional stay. That was refused, and they were directed to, my lord, deposit this entire 2,171 crores, which is the award. They do not do that. They go up to the Honorable Supreme Court. Supreme Court dismissed the SLP with, if my learned friend, I was there throughout, if my learned friend wants the comments of the Honorable Chief Justice at that point, I can make that as well. Saying that you should deposit. If you let the state has led you to do this industry, you should deposit. Review application file, that is also dismissed. Now, quite naturally, my lord, the execution, if it is heard, it is to their advantage because then they don't have to deposit.
Correct.
That is the advantage. So, my lord, to keep the Section 34 proceedings pending is in their own favor to ensure that the whole purpose of the Arbitration Act, my lord, is defeated. Now, my lord, with great respect, this submission, it was said that one court should hear it. We said, yes, the Section 34 court is a substantial court. Section 34 court should hear it. Because, my lord, those substantial. My lord, let me just, my lord.
This court should not be a party between.
Absolutely, my lord. My learned friend has placed all these letters.
So what, Mr. Banerjee, they have already applied before the.
No, we have also applied.
You also applied before the chief. Let the Chief Justice take that.
My lord, today, my lord, if they want an adjournment, my lord, because they have not filed any rejoinder affidavit. My lord, there is a direction by my lord on the last occasion on May 5th to say interest of justice time to extend for a period of 2 weeks from date. This is, my lord, on May 5th, 2025. And this is specially fixed at 11:30 a.m. today. So they have to, my lord, commence their argument on Section 34 if they think, my lord, there's any ground to, my lord, setting aside of the award. It is very easy, quite naturally. They started, my lord, the execution hearing to go and say, now the execution has started. Therefore, you release this so as to, my lord, ensure that, my lord, the 34 gets drowned insofar as, my lord, the execution is concerned. If the execution is taken up first, quite naturally, they'll come and the execution is now taken up.
File the rejoinder and.
My lord, kindly, my lord, on this, my lord, on their prayer, my lord, they want an adjournment of the Section 34 proceedings. Kindly record that. And, my lord, this is a specially assigned matter, my lord. We want to, my lord, do it here.
With regard to the matter is pending.
Let's, my lord, understand, my lord, there. If the Honorable Chief Justice decides otherwise, that's, my lord, up to the Honorable Chief Justice.
This court is concerned.
Correct.
The matter
Correct.
is before the Chief
Not fully agree.
If your lordship has to hear the matter, we will of course have to.
What ultimately? My lord has fixed the matter for hearing today at 11:30.
That's why I'm telling this court cannot be a party.
I'm sorry, this is not the way. I am very disappointed in the state.
Decide whatever it is. If you both say that it is to be released,
no, my lord, I am saying, my lord, kindly start the hearing of the matter.
Court has no interest in any of the matter.
Absolutely.
I am, my lord, personally very embarrassed to make
this court has no interest in any of
absolutely. I fully, my lord, agree with that, my lord. I'm not, my lord. This is my submission. Kindly take up the matter for hearing.
My lord, kindly, my lord, allow me to file the rejoinder in the course
Yes, I
of
am
the day.
taking on record.
And, my lord, I have also prayed, my lord, this matter should be started for hearing today, my lord, by my lord.
Have you served a copy?
Yes, my lord, here, I'm giving him.
So and so appearing for the petitioner, so and so appearing for the respondent. Full stop. The matter is fixed today. Special respondent. Full stop. Counsel for the petitioner has filed affidavit in reply after serving the copy to the learned counsel for the
today, my lord, just now.
Let the same be kept with the record.
Just now.
Full stop. Counsel for the petitioner submit that the petitioner has made a representation before the Honorable Chief Justice of this court for assigning the matter to the Honorable Court which the execution proceeding is pending. And counsel for the respondent has also handed over the communication in which the respondents have objected for assigning the matter to the other bench. Full stop. This court found that
we have, my lord, also said, my lord, this should be, my lord, has seen, my lord. We have said, my lord, it should be assigned, my lord, because, my lord, this matter, this application is a substantial matter, my lord, which has to be heard.
Required.
My lord, perhaps, my lord, recording of that.
And the counsel for the respondent has also made a representation to the Honorable
Because
Chief
this is, my lord, the
Justice,
substantial court, this court should release.
Chief Justice on the ground that that Section 34 application is before this court has been specifically assigned and this court has already heard and this court has already heard and disposed of the Section 36 within bracket 2 application after hearing the party extensively. Full stop. In the said representation of the respondent, it is also mentioned that there is mentioned that the execution proceeding, execution application pending before the court be heard along with Section 34 of the application, which considering the validity of the award on the challenge of government of West Bengal and WBIDC, and before which the matter is already specifically assigned. Full stop. Urge learned counsel for the respective parties. It is fine from the record the matter is specially fixed today at 11:30 a.m. for hearing of the 34 application. But the petitioner has made an application before the Honorable Chief Justice for assigning the matter to the other bench in which the Section 34 application is pending. This could want to go into the controversy between the parties, and as such, for the time being, the case is adjourned till the decision is taken by the Honorable Chief Justice whether the matter is to be heard by this court or the Honorable Chief Justice will assign the matter to the other court. Let the matter appear on 20th June 2025.
Well, may I file this by 1 o'clock today? Well, it is being affirmed now. The original is being affirmed.
No, you said it.
No,
you said it's been affirmed. You want to file it?
Well, I said I'll file it within the course of the day.
No, that's not.
Let us see what the Chief Justice, if it
Very-
transfer, okay, otherwise I'll fix the date.
Very
Yes,
well.
of course.
Then, Malad,
If it is transferred, there is no problem. If
yes.
it is not, then
Of course.
So that, Malad, of
Malad,
course. That, Malad, is.
then I will fix the date.
Yes,
for
Malad.
you.
I'm grateful.
Malad, can it be Malad is directed to appear on the 20th?
20.
Can it be 19th?
19.
Very good.
As to be mentioned or something.
As to be mentioned.
To be
Grateful.
Normal division আছে now commercial division.
Lordship, in this matter, I'm appearing on behalf of the defendant number 1 and 2.
To appear for the plaintiff. Seems that there is some issue with regard to the service of summons because 2 of the parties are in Calcutta and the other 4 are in Bangladesh. So if your lordship sees the requisition we have taken from the office of the sheriff on
2018 service not affected.
10th of April 2025. No, it says that by post it has been done. By post it has been done. Your lordship sees the extreme right hand corner.
Defendants are there. 2.
6. 2. My learned friend is appearing for defender 1 and 2.
No, defendant number 2. Which case? CS number?
106 of 2024.
106.
Item number 18.
Two defendants.
No, thereafter 4 were added.
Okay. 3, 4, 5,
Subsequently.
6.
Correct. If your lordship sees the
Delivery
report of the sheriff.
confirmed on 2nd February 2005 for the defendant number 3.
Yes.
And item delivered address on 6/2 to defendant number 4. And item delivered to address on 2nd February 2005. 25 on defendant number 5. 3, 4 and 5. Item delivered to address on 13th February 2025. Yes.
In spite of that, your lordship, there was a report given by the department where it says that the department has not received the undelivered packets. But if it is served, the question of returning the package does not arise.
They are giving that. Only now delivery confirm is there.
Correct. So, lordship, what we have done through post, we have served the copy of the plaint and the summons. So, it has been done. Now, on the basis of the report, if your lordship sees the last order, 3rd April 2025, your lordship has directed us to again serve by way of post. So, again, if we serve, the same report will come. So, I don't think if your lordship kindly sees, there may not be any requirement for again servicing by post because they have already received. That is what the report says. And there was another note given in the report by the sheriff that it has not been served to embassy. Now, if your lordship, it has been already served by post. So they are aware that there is a suit filed before the Calcutta High Court and they have received the writ of summons. So they are aware that there is a money claim against them. So now, if your lordship, my only humble submission is, if your lordship kindly fixes any date, we will intimate them again by way of post that this is the date fixed for hearing. Kindly come and appear and contest the suit.
Yes. What do you want?
Lordship, apropos to this order, what I want is that today, since they are aware there is a suit filed, because the report says that it has been delivered. If your lordship passes any order and directs them to file written statement and inspection and discovery of documents, we can again serve that order by way of post. They will.
No, but once order again, I pass an order.
Yes, your lordship.
3rd of April.
3rd of April, your lordship has passed an order.
Embassy. So how, unless that order is not recalled, how the court can again?
But I was only submitting was that, is that, will it be required if your lordship wants, it has been served because they have received the plaint.
That is also recorded.
Correct, your lordship has recorded that in para 4. Para 4.
It is not recorded.
No, your lordship has, obviously, your lordship has taken into consideration.
Considering that, I pass an order.
Your lordship, apropos to this order, your lordship, we have written to the registrar on 10th of April to take steps, but the registrar has not taken any step. As per my instructions from my advocate and record, 10th of April.
The writ of summons.
Yes.
Press writ of summons you submitted.
Correct, yes, we have. 10th of April. What is it? Oh, my instruction is that we have written to the registrar. Now we have asked the registrar to comply with this order.
Comply, you have to file the writ of summons in the department through the embassy. Then you can write to the registrar master. It has to be sent through the embassy.
Lordship, the correct procedure, as per my understanding, is that as per this order, we have to intimate the registrar. We have to take out the writ of summons from the office of the sheriff and serve it to the registrar.
That's where is the writ of summons? That's I'm telling you. Unless you writ of summons, how the registrar will take steps?
No, that we have not done.
That's I'm telling. You have to file the writ of summons and you have to request the registrar to take appropriate steps in turn for sending to the embassy.
That is not done.
That is not. And I appreciate, but on that day also you
not pointed out. Lordship sees is only a technicality. It's only a notice that a suit has been filed against.
I fully appreciate your submission, but my hand is tied after this order, unless it is not recorded.
Yes. Correct.
After going through that, this court has passed an order.
In Lordship will extend the time for
plaintiff to take out the plaintiff.
Lordship, meanwhile, we have already disclosed our documents and they have taken the inspection from.
Oh, one thing, this I also was going to submit. Whatever documents the defendant 1 and 2 has disclosed are all photocopies.
All?
Photocopies. No originals have been disclosed.
Retrieve the original documents.
Where is the list of documents as per the Commercial Code Act?
Commercial, they have to give the documents which are in their custody and what
the list of document? No.
If they don't, that is a good ground for us to strike off defense at a subsequent stage. Order 11.
Lordship, the list of documents lies in page number 28 of our written statement, Lordship.
28 of your written
No, that is not in terms of not in terms of order 11 rule 5.
Civil jurisdiction. Right. After the transfer, you have to where is the statement of truth? Lordship, and whether the written statement was amended.
If your lordship they have not done it, the lordship will not give any further hint. We will take appropriate steps.
No, what will happen in future? Again, because after the transfer, initially what has happened? Now we all know the procedure.
Earlier it was.
Now the court is also passing.
Yes.
Department is commercial side and going on. 2-3 judgment I have passed. Subsequently, this when I writing the judgment, I find all these things.
Correct.
Then I started curing all these
defects.
So unless and until then, at the time of passing the decree, you will be in difficulty.
Now, your lordship, obviously, your lordship knows much when your lordship is dealing with this matter. They have to, if they want to, if that statement of truth and rely upon additional law, they have to satisfy the court by.
No, that's why
they could not.
They have to file an application.
Without that, they cannot. They cannot do that.
So and suffering for the plaintiff, so and suffering for the defendant. Number 1 and 2.
Defendant number 1 and 2.
1 and 2. Cool. Mr. Counsel for the plaintiff press for time to take appropriate steps for issuance of fresh writ of summons upon the defendant number 3, 4, 5, and 6. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 29th of July 2020. Next.
Number 19.
Text.
Into 22, we have been engaged as the advocates by the plaintiffs and all our change briefs. Even on the last occasion, I had taken a time that I need to peruse the records, but we have received the records yesterday. There was an issue with regard to the erstwhile advocate on record, my lord. So may I humbly beseech that these may go out of the list with liberty to mention it, we shall come back.
Appointment of receiver was dismissed. Appointment of special receiver taking possession of book.
We have received 3 matters, yet to receive one of them.
Yes.
If this could go out of
Yes.
Yes, I am appearing on behalf.
He is more than happy.
Why I am more than happy?
Because we are not.
Plaintiff is not proceeding the
now.
matter.
As of now, I am not proceeding.
So suffering for the plaintiff, so suffering for the defendant, counsel for the plaintiff, praise for time. Accordingly, case is adjourned. Let the matter appear on 23rd July 2021, 22.
Yes.
19, 20, 21.
22.
19, 20, 21, 22. All.
All. We are yet to receive brief in one of these. By that time, we should be grateful.
Item number 23.
Yes. I am appearing on behalf of the defendant, my lord. Several applications. GA4, my lord, this is that matter which was before my lord Justice Arindam Mukherjee.
Huh?
Several applications here. GA4 is pending adjudication.
GA1, GA3, GA4, GA5, GA6.
The main application was GA4,
What?
which they had filed for
11.
enforcement of the negative covenant. GA4 of 2023. Initially, this suit was instituted in 2021. The agreement was that whatever tea or tea leaves I plucked from my garden, because they were paying the provident fund dues for which the garden was attached, there was a covenant that I will only sell those green tea leaves to the plaintiff. Now, they acted in breach. They were not paying my dues. Alleging breach that I am supplying tea leaves elsewhere, suit was filed and interlocutory application was filed that the negative covenant there in the agreement should be enforced. The learned single judge in 2021 found that they are in fundamental breach of the contract. The application was dismissed. The matter went up before the division bench. Now, 2 learned receivers were appointed to sell the teas which were already lying in my garden. Now, from that, we went to Supreme Court. All the orders were set aside and the matter was remanded back. Now, in 2023, my learned friend filed a fresh application that was GA4, a comprehensive one, where they renewed their prayer once again for enforcement of the negative covenant. Now, that application along with the others are sub judice.
What are the others?
One application is for removal. Yes, one is for receiver's remuneration. I have a counter claim, leave to file the counter claim. All these applications are pending.
4, 5, and 6.
Okay. May I suggest this? This has been coming up to your lordships after a month, and so may I do this since it is pending? It's reserved for judgment. Lordship would kindly direct the matter to. I'm sorry,
Application heard.
Yes. GA4 heard in 2023, reserved for judgment in April 24, 2023, but judgment has not come.
That is to be taken.
Yes, because if ultimately, if GA4 is dismissed, 5 and 6 will also go.
Okay.
Well, let it go out of list. Lordship will kindly give us liberty to mention once the judgment is held.
Suffering for the plaintiff, suffering for the defendant. It is informed to this court that coordinate bench of this court has already heard the matter in connection with GA4 of 2023 and fixed for final judgment. In view of the above, for the present, let the matter go out of the list, liberty to mention.
Okay.
After notice to the parties. Next.
My lord, in this matter, my lord, the defendant number 3 has filed an appeal which is pending before the division bench of Honorable Justice Showmention and Justice Apurva Sinha Ray. I was praying your lordship if this could be, if your lordship pleases to make this matter go out of the list with liberty to mention.
Why?
My lord, the appeal is pending, lordship.
What is the order under challenge?
Um,
What is the order under challenge? Whether it will affect the suit or interim order you are challenged before the appellate court. What order is under challenge?
my
By
lord,
which order you?
my lord,
Order
Honorable,
you are challenged before the the division bench.
my lord,
Against which
order passed by Honorable Justice Orinda Mukherjee.
Correct. Which order?
13 June, lordship.
13 June or 12 June?
12 June, lordship. I beg your pardon, lordship.
13 June, there's no order. 12th June and 14 June, there are two orders. Adjourn for the day, enable the pending. Then 14 June, there is an order. Passing a partial decree, considering the provision settlement operating lawful agreement between the parties and suit is partly decreed. That order?
Yes, your lordship.
In favor of the plaintiff as assigned against the defendant one so the decree be done. This order is challenged.
Yes, your lordship. We have not challenged. Defendant number 3 has filed this appeal.
Defendant number?
3.
3 has filed the appeal.
Yes, your lordship.
But
We have not filed the appeal.
You are for the plaintiff.
Yes, your lordship.
But the defendant number 3, how the defendant number 3?
They were not willing to file the terms of settlement. They were not willing.
But the decree is against the defendant number 1 and 2 only.
Yes,
1 and
your
2
lordship.
only. Not against the 3. Court has passed against the defendant number 1 and 2 in terms of the settlement.
Yes, your lordship.
Challenging that defendant number 3 has filed.
Yes, your lordship.
Huh?
Yes, your lordship.
How the defendant number 3 will be affected?
They were party in the suit, my lord.
Acha. Every right to object. Okay. Consistent suffering for the plaintiff. Consistent none appears on behalf of the defendant. Counsel for the plaintiff submitted. Appellant. Defendant number 3. You have prepared an appeal. Yes. What is the stage of the appeal? Disposed of. Admit the appeal. Interim order will make absolutely clear this the general degree for terms of settlement will not bind the appellant or compel them to perform any act under the unwinded. Affidavit or not in a Census suffering for the plaintiff, census suffering for the defendant number 3. It is counsel for the defendant number 3 submitted. The defendant number 3 has prepared an appeal against the order dated 14th June 2023 and the same is pending for adjudication. In view of the above, for the time being, let the matter go out of the list, liberty to mention.
Grateful, your lordship.
After notice to the parties. Next.
My lord, I appear for the plaintiff. My lord, in this matter, my lord, the plaintiffs are the trustees of a particular trust, my lord. Now, the plaintiff number 4 had passed away, my lord, for which a substitution was carried out. Now, plaintiff number 4, my lord, was a person who had verified the plaint and he was supposed to affirm the affidavit of evidence, my lord. Affidavit of evidence is otherwise ready, but due to his death, my lord, now a new person, constituted attorney has been appointed, my lord, to do the needful regarding to this. Now, my lord, the difficulty is there are 3 new documents, my lord, relating to the appointment of this power of attorney holder, the power of attorney in his favor, and the reconstituted deed of the trust, my lord, which are required to be brought in, which are not a part of the original plaint, my lord. For that, my lord, I have to seek leave, my lord, leave under. My lord, for this new documents, my lord, under the Commercial Courts Act, these are not a part of the original
There's no application.
plaint. My lord, I'll bring an application on record, my lord, kindly.
Census suffering for the plaintiff. Counsel for the plaintiff prays for time for taking appropriate steps for bringing some additional document on record. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 17 July.
And this became necessary because, my lord, he died and the new person had to come.
Next.
I'm grateful.
Not today. 26, 27, 28, not today. Yes. Record and out. None appears on behalf of the plaintiff. None appears on behalf of either of the parties. It is fine from the record. The matter was listed on 24th of April 2025. 24th April 2025. But on the said date also none appears on behalf of the plaintiff. But this court, for the interest of justice, the case was adjourned till today. Today also, when the matter is called, none appears on behalf of the plaintiff and no accommodation is sought for. In view of the above, CS Com 377 of 2024 within bracket old CS 104 of 2022 is dismissed for default. Interim order, if any, stand vacated.
May it please, my lord, I appear for the plaintiff in this matter. Lord.
Yes.
Lord, the plaintiff has already prepared its affidavit of admission and denial, my lord. But, my lord, he couldn't affirm it because, my lord, his battery is being changed, which
You
is
are appearing for whom?
I'm for the plaintiff. So, my lord, right now, my lord, the pleadings are complete, the plaint as well as the written statement. Now, my lord, we are in the discovery inspection stage. We have already prepared our affidavit of admission and denial, my lord. We will just serve it to them, my lord, but it's not being affirmed because the plaintiff, my lord, had its pacemaker installed. So that is why, my lord, he is not available. My lord, 1 week.
Inspection completed.
Inspection, my lord.
My lord, they have not offered inspection. We had offered inspection,
Plaintiff
but
has
they have.
completed the inspection, but the plaintiff has not disclosed their document for inspection to the defendant.
Yes, my lord.
He
They
is
have
the
not
defendant.
disclosed their document.
You have not disclosed the document.
Our documents are common documents, my lord.
I don't know, but on the last occasion, none
I
appears
was
on
not there, my lord. Yes, my lord, the plaintiff was not represented. The documents are common documents, my lord.
So
My lord, if
you
required,
say you
before.
will not disclose any document, you are relying upon that document, then it's okay.
My lord, we will not disclose it. Sorry. Apni ki neven inspection. It's all.
And you have not given
No,
inspection.
you want to take. It's all common documents.
No, no, it is
Very
for
well,
you.
then we'll give it. Then if you want, it's all common documents, their documents, our documents. Very well. Not then we'll give them inspection. I will file an affidavit of admission denial. Within a week, we shall do so.
And they have also not filed affidavit of documents, my lord.
We shall give it by when we disclose it.
Unless inspection is not completed, how the document affidavit is.
We'll file it along with our affidavit.
Concessions appearing for the plaintiff, concessions appearing for the defendant. Counsel for the plaintiff press for time to disclose their document to the defendant for inspection. Accordingly, the plaintiff is directed to disclose their document to the defendant for inspection on or before 26th of July 2025.
26th of July.
The defendant is directed to complete the inspection by 3rd of July 2025.
June.
Full stop. And the plaintiff is directed to file the affidavit of admission and denial document. Parties, you have filed the affidavit of admission and denial? No.
No.
The parties are directed to file the affidavit of admission and denial document within a week thereafter. In the meantime, the parties are also directed to complete the exchange the suggested issues. Release the matter on 22nd July for framing of
For framing of issues. Very well. Extremely grateful.
Next.
I am appearing for the defendant in this last order tower.
Yes.
There was a direction for filing judge's brief, Miller. possibly in the previous order. Our defense has been stuck off.
No examination chief on affidavit is filed. No judge's brief document is filed according to the case adjourned. Then April also the same thing. Praise for time. Today none appears.
In this case, my lord, I will be filing a review petition and also an application under Section 8 of the Arbitration Act.
Lord, I'm not there in the matter, Lord. I've been asked to take a pass over.
Which matter?
This matter, Lord.
Who is appearing?
Who is appearing?
Mr. Dan.
Sanjeev
Dan.
Sanjeev Dan.
His clerk is saying this.
Also.
52 is my I appear for the plaintiff. But it's
My lord, I am appearing on behalf of the defendant, my lord.
praying for this such kind of a prayer for a lordship appointed the commissioner in September. For a direction with a direction to complete it within 4 months. Has not commenced yet. And it's
I am calling the order and I will examine the witness. See, since 10:30 I am sitting idle.
My lord, this time there
Only
are
administrative order is passing. Not today, for this, that.
Second, lordship may have-
Whenever the file will come before me, if the commission not file the report, I will recall the order and I will fix the matter before this court.
But in this out here, Mara, there are voluminous documents. Mara,
What can be done?
be done
Voluminous
before the
document,
commission.
no problem. Sitting idle, some work can be done by this court. See, 10:30 to 12:30, no, nothing. कल से काम करो वो जितना पार्ट हेड वाला जो नॉन कमर्शियल है ना 12 बजे से रखना शुरू कर दे आर नॉट इंटरेस्टेड कमर्शियल में कोई इंटरेस्ट नहीं है एंड आई विल राइट टू द चीफ जस्टिस टू क्लोज द कमर्शियल कोर्ट
My lord, if your lordships kindly allows me indulgence, there can be a fresh appointment of a commissioner, my lord, if your lordship so want.
Same commissioner may be there, but it is completely the fault of the plaintiff. But to be very honest to your lordship, my leader in the matter suffered a personal
My lord, I am not objecting to the situation, but from the January onwards, my lord, if your lordships will see, now it is June.
2020.
Yes. Now, I personally say that I have got no objections. So, for the personal cause of the learned advocate for the other side, senior counsel is concerned. But from January, my lord, if your lordships will see, plaintiff is traveling this where, that becomes also the ground, my lord.
The reason is not sufficient, but
so appearing for the plaintiff, so appearing for the defendant. By an order dated 30th September 2024, this court has appointed an advocate commissioner for recording the evidence of both the parties on commission. When the matter is called today, it is informed that till date the evidence has not yet been started. Counsel for the defendant submitted the plaintiff's time and till date has not taken any steps to examine the witness. Counsel for the plaintiff prays for extension of time and submitted he will reduce the evidence before the commissioner.
But the affidavit is prepared and served, has also been served.
Counsel for the plaintiff submitted affidavit of evidence is affirmed and also served the copy of the same to the learned counsel for the plaintiff. Considering the submission made by the counsel for the respective parties for the ends of justice, time to complete the examination of the witness on commission is extended for a further period of 3 months from date. It is made clear that by the date fixed, if the commissioner failed to complete the discovery and complete the examination of the witnesses of the party, the commissioner shall file the report before this court so as to enable this court to pass appropriate order. The commissioner is also directed that this court find that this is a fit case wherein this court has to fix the date for examination of the witness before the commissioner. Accordingly, the commissioner is directed to examine the plaintiff witness on on 28th and 29th of June 2030 and 5th and
28th is Saturday, my lord.
Saturday, Sunday I am fixing. Otherwise, they will.
My lord, on one in that.
No, no, no.
Please don't, on
28,
Sunday, my lord,
29,
please don't.
5th and 6th, 12th and 13th, 19 and 20, 26 and 27, and 1st and 3rd,
My lord,
2nd and 3rd.
my lord, only one indulgence, my lord.
Let the report be filed.
My lord, on the
Commissioner
holidays, my lord, the court
on
would be
4th
closed also, my lord.
2025. Full list. The parties are directed to pay the traveling allowances of the officers who carry the witness, carrying the record of this court before the commissioner at the rate of 400 GM per date.
My lord, 2nd and 3rd, my lord, if your lordships kindly consider, so I'll be, my lord, please kindly consider.
Then I am fixing a working days.
My lord,
Then
second
working days you are not Saturday, Sunday.
no,
you not
no,
when-
all right, all right. You
Okay, cut then.
No, my
This
lord.
court find that the parties are not interested to proceed with total order court.
No, my lord,
By an
I
order
am
dated 30th
Lordship will
September
kindly retain your lordship's
2024
order,
on
my
the
lord.
prayer made by the counsel for the parties has appointed the commissioner for examination of the witness on commission. But till date, the plaintiff failed to adduce the witness and witness has not yet been started. This court find that taking an order from this court by appointing a commissioner for examination of the witness on commission, but the parties are not interested to proceed with the matter.
My lord, Saturday and Sunday may be
Matter.
fixed, my lord.
The,
Lordship will kindly retain the
the
lordship's
government has enacted the Commercial Court Act for expedite the matter of the commercial, but this court find that in spite of the same, the parties are not interested to proceed with the matter. In view of the above, the order dated 30th September 2024, wherein this court has appointed the commissioner for examination of the witness on commission is recalled. Let the matter appear on 12 बजे से कोई मैटर नहीं है ना 12 बजे से कोई दिन में मैटर नहीं है ना लेट द मैटर अपीयर ऑन आज कितना तारीख है
13th
let the matter appear on 18th 19th 20th June 2025 for witness action
18th 19th
20th of June 2025 at 12 noon for witness action.
So it could have been done before the commissioner as per the
Sorry.
dates were fixed.
Hence for no commission. September, we are on June.
There's nothing.
1 year has been passed.
Nothing to say, my lord. I have
Playing with the court. And that to a commercial matters. And when our court is fixing the matter, you are having a trouble.
But I didn't have any, my lord. I agreed, my lord.
Come in the court. We'll see to that.
My lord, I apologize, your lordship. I apologize.
Come on from next week onwards. Come, we'll see to that. The court will take burden all this.
Lord, unnecessarily lordship will be burdened with this, my lord.
No problem. Government is giving the payment to me for the burden only. I will take the
My lord,
burden.
Lordship will kindly not do that. Lordship will kindly, my lord.
Sorry, sir.
leave this
Sorry.
order.
Sir, whatever your lordship feels, your lordship.
September.
I understand. I'm also making wastage of time of the court.
No. That I have so many times. See, 10:30 onwards, I have no work. I am giving the only administrative orders.
My lord, let the earlier order be restored.
None of the advocates are ready to do the suits matter.
I understand.
Only you persons are interested with the interlocutory. Once interim order is passed, till the matter is come as inspection and document, every time either fracture or gone to the mainland, gone to the foreign, gone to the something else. Since morning, I have not fixed, I have not framed any issues. Out of the 24 matters of the issues. Yes, next call that.
My lord, can the earlier order be
No,
restored? My
no,
lord?
sorry.
Kindly,
Yes,
my lord.
call the matter.
Item number 33, we invite the court.
My lord, item number 33, I am appearing for the defendant, and
My lord,
34, I am appearing for the plaintiff. Both the suits are connected, my lord.
33 and
34, my lord.
yes.
34 is my
My
suit.
lord, I am praying for not today, my lord. Council is.
Pay the cost. Pay the cost, and you tell what of the cost you will pay.
My lord, I am proxy counsel in this
Huh?
matter.
Proxy counsel, why you are appearing?
My lord,
If you are the proxy counsel, why you are appearing? How much payment has been made to you for taking adjournment? I didn't want to open the mouth from sitting here, but you persons are compelling me.
My lord. My lord, if I may.
My lord, in item number 33, the plaintiff is yet to serve us the summons, my lord. My lord, we have not received the plaint yet, have not received the summons yet. My lord, in item number 34, the summons has been served. They have filed their WS.
33, no summon has been issued. When the suit is filed? 33 what क्या suit number क्या है?
Prior to
Huh?
543 of 2024, my lord. What is?
Yes. 2023 case is filed. Why the writ of summon has not, why on steps has not been taken for issuance of writ of summon? I am dismissing the suit. I am dismissing the suit. You have not taken the steps for writ of summon.
My lord, kindly
Record an order.
matter.
So appearing for the plaintiff, so appearing for the defendant. It is fine from the record the suit has been filed in the year 2023. Subsequently, the suit has been transferred to this court. In spite of transfer of the suit from the non-commercial division. No, it
is filed before commercial division.
So suffering for the plaintiff, so suffering for the defendant. It is fine from the record. The suit is filed on. Suit is presented and admitted on 12th of September 2023. But till date, scrutiny has been done.
Yes, my lord.
But till date, the plaintiff has not taken any steps for issuance of writ of summons. Accordingly, this court finds that the plaintiff is not interested to proceed with the matter. Full stop. CS number CS.Com 543 of 2024 within bracket old CS 192 of 2023 is dismissed. Next.
My lord, item number 34.
Yes.
34 is my suit, my lord. My lord, they have filed their written statement in this matter, my lord. My lord, that order be passed for carrying out the discovery inspection, filing of affidavit of admission denial, and
where is the written statement?
They have served us a copy of the written statement.
इसमें written statement है क्या?
They have served us a copy on 16th of January, my lord, this year.
So suffering for the plaintiff, so suffering for the defendant. Counsel for the plaintiff submit that the defendant has already filed the written statement and served to the plaintiff on
16th January
16th
2025.
January 2025. But this court finds that the written statement is not on record. The department is directed to place the written statement on record. Full stop. The parties are directed to complete the discovery and inspection of the document within 3 weeks from date. Full stop. Affidavit of admission and denial of the document be filed within 2 weeks thereafter. In the meantime, the parties are also directed to exchange the suggested issues. List the matter on 29th of July 2025 for framing of issues. Yes, next.
Much obliged, ma'am.
Answer.
I appeared on behalf of the plaintiff. You're supposed to file a judge's brief of correspondence. 50 numbers of document.
No examination chief, no affidavit, no just document for the interest.
My lord, may I be permitted to appear, my lord, in item number 33, your lordship. I was unable to enter, your lordship, due to.
So yes, call the matter.
My lord,
item number 31, my lord, may I be permitted to file the judge's brief of correspondence?
Huh?
Judge's brief of correspondence.
Just verify document.
Document.
Have you served?
No, my lord.
Where is the affidavit of evidence?
affidavit of evidence, my lord, is in preparations, my lord. We can file
In
it.
January 2025.
My lord, the total number of documents is 70. And out of it, my lord, only 60 documents in original has been found, my lord. And rest of the documents are the photocopies and few are
So
electronic documents.
if it is not having the original, how the inspection was carried out?
My lord, they are written statement, my lord, they have not filed their written statement. There's a scope of filing written statement had been struck down, my lord.
Okay.
My lord,
So this is undefended suit.
my lord, it should be appeared as an undefended suit, my lord.
Should be appeared means there is no order for undefended.
My lord, it is a change brief, my lord. I am not aware whether any such order has been passed or not. It is appearing under the heading suit, my lord.
वो जो हम लोग उसमें वो तीन का 12:30 से करो। विटनेस के लिए बोले ना 12:30 से 12 नहीं 12:30 से।
Their scope of filing written statement has
Yes, undependent suit already by an order dated 24th November.
24th November. Very well, my lord.
Okay, file give the judge's brief document to other party. He has a right to cross-examine.
Lordship, I shall do it, my lord. I shall do it within the course of this day, my lord.
When you will adduce the evidence?
My lord, I'll take only 7 days time, my lord.
My lord, I will make a submission here, my lord, if your lordship takes up the plaint, my lord, paragraph page 96.
May I hand over
There
the
is a
judge's
clause of for arbitration, my lord. I will be filing an application under section 8.
No problem.
Lord, after 120 days over.
No, section 8, my lord, section 8.
No defense disclosed.
Section 8, my lord.
Offering for the plaintiff. Offering for the defendant. Counsel for the plaintiff has filed the judge's brief of document. Let the same be kept with the record. Though this suit is going expert is undefended is placed in the list of undefended against the defendant, but the defendant have the right to cross-examine the witness of the plaintiff. Accordingly, the plaintiff is directed to serve the copy of the judge's brief of document to the learned counsel for the defendant in course of the day by tomorrow.
In course of the day. My lord, copy is ready, my lord.
Course of the day. Full stop. The plaintiff is directed to file the affidavit of evidence within 2 weeks. Mr. Please, the matter, give the date for evidence. 12th of August. 12th of August at 2 p.m. for witness action.
I'm grateful.
Next.
Item number 35.
March, written statement was accepted by order 21st March.
Not a belated written statement, my lord.
You are
was
welcome first. After the vacation.
We objected and naturally lost.
Ah.
My lord, kindly give us a cross order of discovery, my lord. We'll come back after that.
Written statement filed?
Yes, my lord. Lord, there was slight delay. They will not filed
that
an
was
application.
allowed.
21st March,
Lordship has been please
Allowed,
to allow
allowed.
it.
Paid the amount?
Yes, my lord.
So-and-so offering for the plaintiff, so-and-so offering for the defendant. List of the parties. It is fine that defendant has already filed written statement after serving the copy to the learned counsel for the plaintiff. The parties are directed to complete the discovery and inspection of the document within 3 weeks. 4 weeks.
4 weeks.
4 weeks. Full stop. Affidavit of document be filed within 2 weeks thereafter. In the meantime, the parties are also directed to exchange their suggested issues. Please the matter. 4 weeks, 2 weeks, 6 weeks. Okay. This is the matter on 30th July.
Lord,
for framing of issues.
It's been statements of admission and denial also.
That's right.
Oh, I'm sorry.
Grateful, my lord.
Hey.
My lord, I appear on behalf of the plaintiff led by Mr. Chakravarti, my lord. There's an application under Section 8, my lord, which was being heard by your lord.
My lords, on 26th, Mr. Ratnako Banerjee argued the matter. My lords, I will just give a brief background. He is stuck in court number 36. He will be here any point of time. My lord, it's a suit they have filed seeking some indemnity claims against me.
You are appearing for defendant.
My lord, defendant number 1. My lords, they are claiming some relief under an agreement which the parties negotiated at length and then it got terminated. There is an arbitration clause in that agreement, my lords. I'll take you directly to the
Have you
agreement.
filed an application?
My lord, section 8 application.
What GA number?
GA number 3, perhaps.
GA number 3. Three nahi hai.
But it was already part heard. That I believe we just
want to.
GA 2, not 3.
2. Our is GA number 2, my lords.
Yes.
Well, without taking your lordships through the papers, just let me just give your lordships a brief gist of it. Plaint file. Now, two things, one is we have filed an application under Section 8 that the entire dispute is covered by an arbitration clause. And it has to be referred to arbitration. Who are we? We were the erstwhile investors in East Bengal Football Club. And the entire dispute stems from a shareholders agreement, a share subscription agreement and a shareholders agreement. And we will just show to your lordships that the entire what the plaint, and I can't go outside the plaint, the reliefs that they have paid for in the plaint is squarely covered under the agreement, under the shareholders agreement and the share subscription agreement. Because I cannot, at this stage, it's like an order 7 rule cannot go outside the purview of the plaint that has been filed in this suit. But before that, kindly notes 2 dates are very important, 2 facts are very important. Respondent number 2, whom they have impleaded.
You are for the 1.
I am for respondent number 1. Okay. Respondent number 2, Quest East Bengal FC Private Limited, is a company which is already under liquidation under the provisions of Insolvency and Bankruptcy Code. So they could not have filed this plaint against them or the suit against them. So this is a non-starter.
What is the there is any prayer?
Yes, I'll come to that. But before that, would your lordships kindly once take up, I'm sorry I did not annex the plaint in my application. Would your lordship just take up the plaint relief first and then, I'll show your lordships the pleadings and, this thing. Kindly takes up, the plaint once.
Yes.
Kindly sees, the prayer that they have made in the plaint. I think, it's there in the petition also. I can show to your lordships, page 30. Yes, or kindly sees a prayer they have set forth in the petition itself at page 31, para 52.
Para 31?
Page 31, para 52.
Of the plaint?
Of the petition. Very well, your lordship is taking up the plaint. Very well, I'll just show from the plaint itself. I'll show from the plaint. May I show the prayer internal page 35 of the plaint? It's there in the petition itself. It's at page 536, but your lordship has a plain copy. Kindly sees the prayer. After 12A, decree for declaration that the plaintiff is not liable for the claims of defendant number 5 to 14. They were former players of East Bengal Football Club. As stated in para 35. Kindly sees B is very important. A decree for declaration that clause 4.4b of the termination agreement dated July 16, 2020 does not extend to the claim of defendant number 5 to 14. This agreement also has a termination clause, which arbitration clause, which I show to your lordships. Then, decree for declaration that the defendant number 1 and 2 are liable to indemnify the plaintiff for the claims of the defendant number 5 and 14, 214, more particularly stated in paragraph 35, as well as the claim of which any other person has made or make against the plaintiff in respect of club sporting activities or contract, or with the defendant number 1 and 2, including all costs and expenses incidental thereto. Then D, a decree for declaration that the plaintiff is entitled to reimbursement from the defendant number 1 and 2 for all payments made and stroke or cost incurred towards the claim of defendant number 5 and 15.
Yes.
A decree for mandatory injunction directing to indemnify, then mandatory injunction, permanent injunction. And then I also a decree for kindly sees I at page 37, internal page 37 of the plaint. A decree of delivery up and cancellation of the orders passed by the defendant number 3 being annexed and so on, and the same be adjudged as null and void. And then J, a decree for delivery upon cancellation of an email sent to by the defendant number 3 to the plaintiff. These are the plaint. Now I'll show the plaint. Before I come to the plaint, please now let's first have a look at the agreement between the parties, the MOU at page 39, volume 1.
Yes.
39. 39. But this is GA2. No, minus mark. Minus mark. First, your lordship sees page 39. Your lordship has got it, from GA2.
Yes.
Memorandum of understanding.
39.
Because your lordship has taken up GA1 or
GA2.
This is I'm sorry, kindly takes up GA1 once. I'm sorry, kindly takes up GA1. Okay, very good. Page 39. They themselves have annexed it, kindly take up page 39 of GA1.
Yes.
This was the memorandum of understanding, executed on, kindly notes the date, 5th July 2018.
Yes.
This is, your lordships would see between East Bengal Club and Quest Corp Limited. And your lordships would see formation of a joint venture company at page 40. The parties have agreed to incorporate a joint venture company for the purpose of managing the commercial affairs of the club. The joint venture is yet to be incorporated as on the date of the MOU. And the name of the joint venture, your lordship would see clause to recital 2 at page 40. The name of the joint venture company is proposed to be Quest East Bengal FC Private Limited, and such other name as may be approved by the Register of Companies. This is the company now, which has gone into liquidation now under IBC. Now, kindly takes up page 43. A share subscription and a shareholders agreement was executed between Quest East Bengal FC Private Limited, kindly sees company, East Bengal Club, that is the plaintiff before your lordships. Respondent number 1, Quest Corp Limited, he is the investor. Lordship, please. Now, straight away, your lordships would come to first. I just want to show before showing the arbitration clause, because since your lordship has seen they have challenged the termination of the agreement in termination, kindly comes to page 71 of this agreement. I am sorry, of this petition. Clause, the termination clause, clause 17.
Yes.
I just wanted to show that the entire subject matter of the plaint is actually the subject matter of the share subscription and the shareholders agreement, which has an arbitration clause.
Yes.
Termination and consequences of termination. This agreement may be terminated at any time by mutual written consent of the parties. In the event of default of any of the parties of the terms and conditions of this agreement or applicable law, the other party shall have the right to terminate the agreement immediately in the event of such a default is not remedied within a period of 60 days from the date of such notice. Now, 17.3 kindly sees, in the event that the club fails to participate in the Indian Super League or the league formed by combination of ISL or I-League or the equivalent of highest level of football league competition played in India, so-and-so Asian football, so-and-so, within 3 years of the closing date, the investor will have a right to terminate this agreement and any other agreement executed by and between the company and the club. Now, kindly turns the page to 71. This is very important. Kindly sees 18.4, and my respectful submission is that the arbitration clause is wide enough.
Yes.
Kindly sees 18.4. Yes, I'm coming to that as well. Please see dispute resolution. In the event of any dispute claim or controversy arising under or in relation to the terms of the agreement dispute, the parties shall use all reasonable endeavors to negotiate with a view towards resolving such disputes amicably. If a party gives the other party notice that a dispute has arisen, dispute notice, and the parties are unable to resolve the disputes amicably within 15 days from the date of service of the dispute notice, or such longer period as the parties may mutually agree or parties thereto, then the dispute shall be referred to and finally resolved by the sole arbitrator to be mutually appointed by the parties to the dispute. If the sole arbitrator is not appointed within a period of 30 days from the expiry of the first 15 days period of the arbitration, shall be conducted by an arbitration panel and shall consist of 3 arbitrators comprising of 1 arbitrator appointed by the investor, 1 arbitrator appointed by the club. The arbitrator so appointed will appoint a 3rd arbitrator who shall serve as the chairperson of the arbitration. Seat of arbitration shall be Kolkata, and the arbitration proceedings shall be governed by the provisions of the Arbitration and Conciliation Act as amended from time to time. All arbitration proceedings shall be conducted in English, so-and-so, so-and-so. The arbitration will be final and binding. This is the first arbitration clause in the share subscription and the shareholders agreement. Now, Millard, there was another agreement. There was a termination agreement. Terminating the understanding between the parties, terminating the arrangement between the parties. Your lordships would find that at volume 3, page 372.
Of GA1 or GA2?
GA1. I'm just only referring to from there. They have annexed it, Millard. So, Millard kindly takes up volume 3, page 372. The first stamp paper, that's a bit not legible, 372, but it starts 374 is the relevant. Yes. Now, 374, your lordships would see, this is the termination agreement dated 16 July 2020, executed between Quest East Bengal FC Private Limited, respondent number 2, Plaintiff East Bengal Club, and kindly sees 3, Quest Corp Limited, the respondent number 1.
Yes.
Kindly sees the company and the club and the investor shall be referred to as a party and collectively as parties, so and so. Now, kindly sees background B, the shareholders agreement has been referred to.
Yes.
The terms and conditions. Now, kindly sees C. This is very important. 375. Parties are now desirous of terminating the shareholders agreement on mutual consent of the parties and effecting transactions contemplated under the shareholders agreement on account of such termination. Further, the club has agreed to transfer the club subscription shares to the investor, and the investor has agreed to purchase the club's subscription shares, being all the outstanding shares held by the club in the company, subject to the terms and conditions set out in this agreement. This agreement outlines the terms and conditions and process agreed to be followed by each of the parties so as to effectively terminate the shareholders agreement and effect transactions contemplated, so and so. That is to reward the club an exclusive right and enjoyment of contracts. Kindly note this: contracts, licenses, permissions, and facilities pertaining to the club's sporting activity transferred to the company pursuant to clause 14.3 of the shareholders agreement. And number 2, effect the transfer of the club subscription shares from the club to the investor. But what is more important is, kindly straight away comes to page 380. I'm sorry, I just also want to show once 378 before I come to that. 378 first. Kindly sees clause 2.
Yes.
Termination of shareholders agreement and revert of club sporting activity rights to the club. with effect from the date on which all actions contemplated and has got it, Malad?
Yes, yes.
Under clause 3 have been duly completed to the satisfaction of the investor, termination effective date. Parties agree that the shareholders agreement shall stand terminated. So this Malad stands terminated. Now please come to Malad now clause 4. This is very important, which what is the consequence of termination? And Malad, what was the subject of this? Please see this. From the termination effective date, none of the parties shall assume any financial, kindly notes, financial, commercial or legal obligation towards any of the other parties except as expressly specified herein. Your Lordship has seen the claim. The petitioner has made claim on account of the players, the erstwhile players. They're now trying to raise it upon me. So, Malad, my endeavor to your Lordship perhaps have to examine whether that forms part of this particular agreement or not. If that is, then it has to go for arbitration. Now, please see 4.2, Malad, I'm not troubling your Lordships. What is important is 4.4 at page 380.
Yes.
Specifically and without prejudice to the generality of clauses 4.2 and 4.3, the parties have also acknowledged, agreed and accepted that on and from the termination effective date, kindly says A, neither the investor nor the company shall assume any responsibility or obligations in respect of the club sporting activity from the termination effective date. Respondent number 1, respondent number 2, nothing. B kindly sees, this is very important. If, and your Lordships will perhaps mark this, Malad, this is the bone of contention. If, as on the termination effective date, there are any actions, claims, this is very important, claims, investigations, proceedings pending before the AIFF or any of its disciplinary bodies or judicial bodies or government authorities as regards any actions, inactions of the club or its players for or in connection with any club sporting activity, neither the investor nor the company, well, that's respondent number 1 and 2, shall bear any liability, responsibility or legal obligations in respect of any such proceedings, and that the club shall be solely responsible for the manner. Who shall be responsible? The club shall be solely responsible for the manner in which such proceedings and our further liabilities arising thereof would need to be handled. Notwithstanding the foregoing, the club shall not be entitled to represent the company or the investor in proceedings. The club hereby undertakes to keep the investor informed of the progress and developments and provide the investor with copies of all relevant documents and such information as may be requested from the investor from time to time or in connection with the proceedings. So, Malad, what does clause 4.4b says? Any claims in respect of any players which are pending before any AIF, Lordship, All India Football Federation, the World Football Federation, the judicial bodies, anywhere, any claims arising out of any players before this forum, neither the respondent number 1 nor the respondent number 2 will be responsible. It's only the club who has to bear it. And your Lordship says, now they want a declaration that this
is to be null and void.
Yes. That's their prayer, principal prayer. And they say that, look here, having Malad's consciously and Malad's greatest of respect, they themselves have disclosed this. It's not a case made out by them in the plaint or the petition that they were coerced to sign this agreement or there were any undue influence, Malad, which makes this particular contract.
What are the grounds they are challenging?
Yes, now I'm coming to that. Before that, Malad, I'm grateful for that question, Malad. Just give me 2 more minutes before I come to that answer that question. Please now, Malad, what is more important is, please, after showing your Lordships 4.4 and 4.5, please kindly comes to straight away has Malad 387. And also, and this is also very important, I just want to show 387. I'm sorry, before that, Malad, kindly, will your Lordships kindly take 386 once, clause 10. They're asking me to indemnify.
Yes.
It's actually the other way around. You cannot lead an evidence, you cannot run a case contrary to the terms and conditions of a written contract.
Okay.
That's a settled law, Malad. Please see 386 clause 10. Indemnification. the club covenants and agrees to indemnify and keep indemnified, save, defend, and hold harmless the company, investor, and its affiliates, and each of their respective directors, employees, agents, representatives, successors, and assigns. Kindly sees indemnified parties to the fullest extent permitted by applicable law from and against to pay or reimburse the indemnified parties for any and all losses arising out of or in connection with any or all claims, demands, damages, liabilities, loss, potential loss, or notice of claims issued by a third party, collectively claims, in connection with the following. Number one, inaccuracy or representation or in any breach of the club's representation warranties. Number two, this is very important. Any matter in relation to, arising out of, or in connection with any club sporting activity undertaken by the club or in conduct of the club business. Then any impact on the brand goodwill, any act of fraud, misdemeanor. Two is very important. Because now they are saying claims have been raised against the club on account of actions taken by the former players for which you need to indemnify me. It's the other way around.
Yes.
It's the other way around.
Yes.
Now, Mulad, would your lordships kindly see indemnify? I'm not troubling your lordships with 2 also. 2 is very important. But now, Mulad, what is important is 387. Please seize this. Whether this court retains jurisdiction also to enter. No interim order. Let me be very fair, Mulad, candid. They've not been able to get any interim order. There is no interim order. I have filed my Section 8 first without prejudice to my Section 8. I've also filed my written statement subsequently because it's a commercial suit. If I would have perhaps not succeeded in the Section 8, your lordships are generous. You have been very kind enough to extend time sometimes to us. Well, we know that. But let's kindly see 387 now, clause 11.3. There is an exclusive jurisdiction clause, governing law and jurisdiction. Agreement shall be governed in all respect by the laws of India, subject to provisions of clause 11.4, dispute resolution. The courts at New Delhi shall have exclusive jurisdiction to determine and disputes out of or in relation to the terms of this agreement.
Forum selection.
But Lordship knows the catena of judgments from ABC Laminate. In fact, your lordships have allowed Order 7, Rule 10, return the plaint on the ground also. Just seen citing Southeast Asia, ABC Laminate, all the other judgments.
Yes.
Now, 11.4. But let me also be fair. I do not have an Order 7, Rule 10 right now because I've said that it's governed by the arbitration. Why, 11.4 is the answer. 11.4, is the dispute resolution clause at page 387. Kindly sees. In the event of any dispute, claim, or controversy arising under or in relation in terms of this agreement, the parties shall use all reasonable endeavors to negotiate with a view towards resolving such dispute amicably. If a party gives the other parties notice that a dispute has arisen, dispute notice, and the parties are unable to resolve such dispute amicably within 15 days from the date of service of the dispute notice, or such longer period as the parties may mutually agree prior thereto, then the dispute shall be referred to and finally resolved by a sole arbitrator to be mutually appointed by the parties to the dispute. If the sole arbitrator is not appointed within a period of 30 days from the expiry of the
clause which is in that agreement.
Yes. So, Malad, today and the seat of arbitration shall be Kolkata and will be governed by the. Malad, I wanted to show 2 things.
Why the arbitration in Calcutta and the proceedings in New Delhi?
Malad, I'll tell your lordships, it is not the case also that Delhi, because your lordship has also held several judgments that I cannot confer jurisdiction on a place which in normal course will not have jurisdiction. But here, Malad, my office was there in Delhi. So, Malad, perhaps that's the why, Malad, not the corporate office is in Delhi, I'm told, Malad. That's my instructions also. Malad, I'll figure that out also. Okay. Now, Malad, most importantly, I wanted to show 2 things. Malad, what is my relationship with the club? I was an investor. I'm sorry.
Sorry, Malad, I got stuck in the other matter. I'm so sorry.
No problem.
I mean, just a termination. Arbitration. Malad, I just wanted to show.
Sorry, Malad.
I just wanted to show 2 things.
Any Banerjee.
Malad, at least the first initial is also.
My lord, once he told me, I'm
No,
sorry,
no,
my lord, I'm just
no,
writing.
no.
I just wanted to, just before
Bring it
Malad,
up.
I say this, but my relationship with East Bengal Club stems from the fact that I stepped in as an investor. So I just showed two things. The cause of action itself arises that first, the shareholders agreement, which has an arbitration clause. The termination agreement, by which that relationship also got terminated, has an arbitration clause. So any disputes, Malad, between me and him, both, Malad, it's both ways. But jurisdiction clause, Malad, I'm not. Now, Malad, what is more important is, Malad, if your lordships would now see, Malad, the prayer in the plaint, which I showed to your lordships, 4.4b.
Yes.
It actually prayer B of the plaint squarely, if your lordship keeps the plaint, Malad, the prayer B of the plaint for a moment, and your lordships would kindly takes up Malad, clause 4.4b of Malad, the termination agreement. Malad, which I showed to your lordships at page 380
Yes,
of
380.
GA1.
380.
Kindly see prayer B.
Yes.
Both kindly sees what prayer B is. Prayer B is actually Malad, relates to 4.4b of the termination agreement, of the termination agreement, which is covered by the arbitration clause.
Correct. That's I'm telling in both.
So, correct.
If we go by both agreement, in both agreement, the
I'm so
arbitration
grateful.
clause is there.
So in both, Malad, and Malad, your lordships would also see, I showed to your lordships, the indemnification clause, the other prayers. That's clause 10 of the termination agreement.
Yes.
But I just,
Yes.
I think. I'm led by Mr. Ban.
Thank you. I'm so sorry, my lord. Kindly, my lord. My lord, today, my lord, if I may just, my lord, submit, my lord, section 8 application. But apart from, my lord, the Honorable Supreme Court going first, my lord, what is the scope, section 8, section 11, with the Adjolia. Now, my lord, that interplay judgment is the last judgment on the question of, my lord, section 8 and section 11. Now, my lord, from the law, it appears that, my lord, if there is an existence of an arbitration agreement which is not denied, or, my lord, which is prima facie, my lord, shown, then, my lord, disputes have to go to arbitration. This seems to be, my lord, the law now, my lord, as
As
it
on today.
stands. And the scope of inquiry is really very limited so far as court is concerned. And the logic being that if it is shown an arbitration, then don't waste really, or don't get into this public forum court
Cannot
trial.
inquire into it.
Yes,
The court is
yes.
satisfied that both the parties to the agreement, both the parties are the parties to the agreement, and there is a clause,
Arbitration agreement, that's right.
clause entered by both the parties with the open eye.
That's right.
And it is
Absolutely. No, that's the law. That's my lord has
directly
accurately,
it is
accurately, my lord, described, my lord, that is what the law is. No, my lord, here, that's why, my lord, I do not see, my lord, any dispute A with the parties and B, my lord, with the arbitration agreement, which governs the relationship of the parties. Now, my lord, to say whether this comes within the scope, not within the scope, or this is a different, my lord, that also determination has to be done by the learned arbitrator. Otherwise, my lord, will be dissecting.
Correct.
My lord, the question whether this comes within the jurisdiction or not come within jurisdiction, because I thought, my lord, they have really, my lord, if I might use, my lord, the Japanese word harakiri, which means, my lord, Japanese word for suicide, by what my learned friend just showed, my lord, the prayer B.
Yes.
Correct. If in a suit, as soon as you bring into question,
So that's why you ask what is the ground for challenging the 4.4? What is the ground challenging? What is the ground for challenging that clause in the plaint?
my lord, they say, my lord, misrepresentation. My lord has seen, my lord, what has happened. Club taken over, there were, my lord, disputes. Then, my lord, we said we are going away. The agreement, my lord, got terminated. We said all players, whatever had to be done was settled at that point of time. The rest is your problem because we are walking away. If there are any claims, then that is your problem. That's how, my lord, they accepted with their indemnification clause and all that. I don't know. Have you shown the clauses yet?
Yes, yes.
Yes. So, my lord, we'll see, my lord, that's the clause which says indemnification. You have to really indemnify us.
What is to be done?
What is to be done? So, any dispute touching upon that agreement will have to go to arbitration. Today, my lord, is not, my lord, the court is not going to sit and say, let me analyze whether this dispute comes within, does not come within. Because you yourself say, because that declaration, and my lord, may I just start from there, my lord, which my learned friend has just shown, prayer B, that itself, even if, my lord, this declaration is required at page 536, my lord, of the petition.
Yes.
A decree of declaration that clause 4.4b of the termination agreement dated July 16 does not extend to the claims of defendant of 5 to 4. Itself means
there was a clause.
Itself means, my lord, that you have to look into the agreement.
So unless and until that has not been declared as null and void, so they have
absolutely
bind under the agreement.
Correct. Correct. They will really have to go back to the arbitrator under this agreement to say, look, this clause is not applicable to these claims.
That's what I'm telling.
That is within the jurisdiction of the learned arbitrator.
That declaration is not
Correct.
made by the.
So that is why, my lord, we say, my lord, it is really not something, my lord, which requires, in that sense, a tremendous amount of hearing to say, because the court will not, because I would have appreciated my learned friends, my lord, stand if there was no arbitration agreement, they were saying this part of the suit or not part of the suit or doesn't come within the clause. That is, my lord, understandable. But the moment it is hit with, my lord, an arbitration agreement, then all this jurisdiction is also with the arbitrator.
No, it is the duty of the plaintiff to satisfy why that clause is not
Correct.
applicable. That is,
My lord, duty of the plaintiff to satisfy that the clause is not applicable before the arbitration forum.
yeah, that's what I'm telling.
That's right.
Not applicable
Yes,
for
yes.
the arbitration.
So,
that's why file the
Correct, correct. So it is not open to them to come and say, I will now satisfy this court that why this clause doesn't apply.
That's what I'm telling.
Correct, correct. Now, my lord, I want to show, my lord, one thing. My lord, even, my lord, on the prima facie view, my lord, so as to, my lord, satisfy, my lord, the conscience of the court. Just let me exit. Huh? Yes, yes, yes. My lord, kindly look at, my lord, what they rely upon. Just let me get my this pages 4. Yes. My lord, all these claims which they say, my lord, are because they, my lord, accuse us of misrepresentation. They say, oh, you knew the claim was there, but you still entered into this agreement, and therefore we are now stuck with it. Just, my lord, also on the question of prima facie, though, my lord, perhaps I don't need to show that, but still I'm showing it. My lord, kindly take, my lord, volume 3 of, my lord, the petition, IAGA number 1.
Yes.
1, right?
Page.
My lord, page. My lord, will recall, my lord, the termination settlement agreement, my lord, is 16 July 2020. Now, kindly look at, my lord, the claims which they annex. First, my lord, is page 400. It starts at page 398.
Yes.
And kindly see, my lord, page 400. At the top, sorry, my lord. This is volume 3, my lord.
Yes, yes, got it.
On 10 September 2020, the plaintiff player lodged a claim.
Against the club before I.
So, my lord, this is 10 September 2020, subsequent to 16 July 2020. So, this claim did not exist. Because what do they say? They say, my lord, these claims have come up. Claims of the players have come up. They say, I have misrepresented and I did not disclose all these claims to them. That's their case.
Correct.
Now, I am showing that, sorry, these claims have come up subsequent to the agreement. Where is the question of me disclosing any of these claims?
The claim is up on 10 September.
Yes. And, my lord, the agreement, my lord, has seen, my lord, is 16 July 2020.
The agreement is on 16 July. Page 71, I think.
That's, my lord, at page.
Page 70.
Yes. Page 372. Same volume, my lord, at page 372, my lord, will find.
Yes, 16 July.
Yes. At 374, my lord, will find 16 July 2020. And Malad, since Malad is taken that, I'm sure Malad that clause Malad would have 4.4b Malad has already noticed at page 380.
Yes.
If as on date of effective date, termination, if there are any actions pending, claims, investigation, proceedings pending before the FE and such, or governmental inaction of the club or players and such, any proceeding, then the club shall be solely responsible. Well, that's 4.4b at page 380. So even if it was pending, Malad, it's responsibility of the club. Leave aside, Malad, that it is Malad subsequent.
That's why they are challenging this.
Yes.
Because of this clause, they are bound.
They're bound. So what correct. So what they say, oh, actually you misrepresented. You did not disclose this. Therefore, I come outside.
It has to be go out.
Correct. Therefore, I'm filing a suit.
That is the.
But I'm saying, Malad, 4.4b covers not only pending claims, but anything which might arise in future also. And even pending claims. So the basic case Malad, that I did not disclose it, Malad, irrelevant.
What has happened? It's still pending the claim of the players.
Malad, 4 are decided. The others, Malad, which Malad there, it's there. Malad, I'll just give the pages. Page 400, Malad, considered one claim. Then Malad, the next claim is Malad starts at page 410, Malad will find. 410, Malad, it starts. And again, Malad, kindly look at the date at 412. At the bottom, proceedings before FIFA. Paragraph 14, Malad will find the date is Malad 21st December 2020.
Yes.
At 412.
412, 6th May. No.
No, Malad, at the bottom. This is Malad with regard to mutual termination agreement to the claimant. At the bottom, Malad will find on 21st December 2020, claimant filed the claim at hand.
Okay.
Paragraph 14.
Yes. Yes.
Now, Malad, 424, Malad, is the third claim. And Malad, at 427. 424, Malad, is the third claim. And at 427, paragraph 6 again.
Para?
6. On 10th September 2020, the player lodged a claim against the club before FIFA. 427.
Same.
Yes.
10th September. First claim as like first.
Yes, correct. Absolutely. And the last one which they annex, Malad, this starts at four 434 and at 438. 434 it starts. And at 438. Malad, paragraph 2 at the bottom of the page, the first line of paragraph 2. In view of the above, the claim was forwarded to the club on 7 November, correct. So all are Malad post Malad 16
Yes.
July 2020. I'm even showing Malad the worst case scenario. Because even if it was pending Malad, still also Malad, it is covered Malad by that clause.
Yes.
Now Malad, just 2 more documents before I just show the law. Email you show me. Malad, kindly look at page 461.
ये volume 4 देना.
Two things I want to show, Malad. Sorry, Malad. In this volume, same volume, Malad, 369 first, Malad. I'm so sorry. In volume 3 first, that's a letter of Malad, 14 July 2020. Is there?
Yes.
Malad, see, Malad. Kindly see, Malad, this is our letter, Malad. It's by way of Malad reply further to our email of July 13, 2020. Please refer to your comments on clause 4.4b of the draft termination agreement, which is reproduced hereunder for convenience. This is Malad when 4.4b was discussed. Malad, in that clause which I showed, page 380. While Quest is not aware of such proceedings at the present time, Club is also well represented through 4 Club nominee directors aware of all company Club proceedings. Quest is happy to discuss any specific proceedings that Club may be aware of, concerned with, but Quest would prefer that this provision to be applicable in relation to all proceedings, if any, that may be pending as on the termination date. Then please see revised language to offer the Club with greater comfort. We have expressly defined proceedings to be in connection with Club sporting activities. Then this is a discussion prior to, and then since the term proceedings answer, then kindly turn over the next page.
Quest response.
Quest's response is very important.
Yes.
The investor and the company are not aware of any proceedings pending before the AIF or any of its receiving proceedings or judicial bodies or government authorities. So this shows why, because nothing had been filed at that point of time. And then further, the company had terminated contracts with 21 players, coaches, technicals through mutual termination. Sansaj, 8 players avoided. And similarly, so far as your comment on clause 7.3 of the draft termination is concerned, which set out below hereunder, given the fact that the club rights are reverting to the club on termination, company would not be in a position to coordinate or engage with the concerned sport authorities. However, the club shall offer all support to ensure smooth transition club sporting activities to the club. This is prior to the agreement being signed. Now, kindly see the next letter at 1st March 2021. This is volume 4.
Page
461.
Yes.
This is what they say. Shocked and surprised, receive email from concerned CEO. We have had no opportunity. We have had no opportunity to deal with the allegation of players in as obliged under the termination agreement. Quest Club have forwarded all notices to them for the being. While reserving our rights to address the matter in detail merits, we'd like to point out that all these players were signed by Quest Corp. Terms of the termination agreement entered with Quest Corp, Quest Corp Limited. Kindly similar. Next. We are only liable to bear liability as players who would approach AI prior to the termination. So they say only liable to bear liabilities of players, and I don't know how they say prior to.
Who had approached the IF prior to the termination. Yes.
Now, kindly look at the law. Kindly look at interplay. I only think interplay is the one we should.
The latest one. The latest one.
Yes, that's the latest one. In other matters, I wrote Vidyadroli, then again I'm scratched out Vidyadroli to say now look at interplay. Though I don't think on the section 5 and 8 it doesn't, or 8 and 11 it doesn't make. It is really on the stamping of the agreement which was. This is 2024. You want a copy? 2024 6 Supreme Court cases, page 1. Dr. What is fully aware of. Kindly come to paragraph 81. At page 60.
Yes.
Should I give the paragraphs first, which I want to lap on? That may be convenient. 81, 82, 86, 86.1, 88, 89, 147, 154, 185, and 206.2.
6.2.
206.2. Section 82 I'm reading.
Yes.
Section 5 begins with the expression notwithstanding anything contained in any other law for the timing in force, non-obstante clause in Parliament's addition into Article 5 of the model law. It is of wide amplitude, sets forth the legislative intent of limiting judicial intervention during the arbitral process. In the context of Section 5, this means that the provisions contained in Part 1 of the Arbitration Act ought to be given full effect and operation irrespective of any other law for the timing in force. It is now an established proposition of law that the legislator uses non-obstante clause to remove all obstructions which might arise out of the provisions of any other law which stand in the way of operation legislative incorporates non-obstante clause. Then, my lord, kindly come to non-obstante clause is appended in a provision to give such provision overriding effect over other provisions of law. In my lord, then in Chandavarkar Sita, that is my lord quoted. Then kindly look at my lord paragraph 86.
Yeah.
Because Section 5 my lord sets the mood my lord with regard to my lord as to how much intervention. Similar to Article 5 of the model law, Section 5 uses the expression in matters governed by this part, uses the expression circumscribes scope of judicial intervention to matters expressly governed by Part 1 of the Arbitration Act. Matters governed by Part 1 inter alia include. Then, my lord, 86(1), Section 8, which mandates judicial authorities refer parties to arbitration when prima facie there is a valid arbitration agreement. My lord, I'll just take 5 minutes.
Yes,
my lord.
yes, no
I'll
problem.
just finish it because I don't want to unnecessarily, my lord. Then, my lord, 88. One of the main objectives behind the enactment of the Arbitration Act was to minimize the supervisory role of courts in the arbitral process by confining it only to the circumstances stipulated by the legislature. For instance, Section 16 of the Arbitration Act provides that the arbitral tribunal may rule on its own jurisdiction. This is very important. Including ruling of any objection with respect to the existence and validity of the arbitration agreement. Effect of Section 16, bearing in view the principle of minimum judicial interference, is that judicial authorities cannot intervene in matters dealing with the jurisdiction of the arbitral tribunal. Although Section 8 and 11 allows courts to refer parties to arbitration or appoint arbitrators, Section 5 limits the courts from dealing with substantive objections pertaining to existing validity of arbitration agreement at the referral or appointment stage. Referral court at Section 8 or Section 11 stage can only enter into a prima facie determination. Legislative mandate of prima facie determination ensures that the referral courts do not trammel the arbitral tribunal's authority to rule on its own jurisdiction. Then Section 5 is 89, is of aid in interpreting the extent of judicial interference under Section 8 and 11 of the Arbitration Act. Section 5 contains a general rule of judicial non-interference. Therefore, every provision of the arbitration ought to be construed in view of Section 5 to give true effect to the legislative intention of minimal judicial intervention. Then, my lord, kindly come to straightaway 147.
Yes.
At page 81. my lord.
Yes.
In the Indian context, Section 8 provides that when an action is brought before a judicial authority in a matter which is the subject of an arbitration agreement, such judicial authority shall refer the parties to arbitration on an application made by a party to the arbitration agreement or any person claiming through or under him not later than the date of submitting the first statement on the substantive dispute. Section 8 mandates the judicial authority to refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Section 8 is based on Article 8 of the model law, which provides that the court before which an action is brought in a matter which is the subject of an arbitration agreement shall refer the parties to arbitration unless it finds that the agreement is void, null and void, inoperative or incapable of being performed. It is evident that Section 8 has made a departure from Article 8 by using the expansive term judicial authority rather than court. Intention legislature to provide an expansive application can also be gauged from the fact that the expression unless it finds that the agreement is null and void, inoperative, inapplicable being performed does not find place in Section 8. Then, my lord, 154. My lord, 154, my lord, it's on the question of judicial interference, not required. Then, my lord, 180. At my lord, page 93. My lord, I refer to this paragraph only, my lord, because it talks about Section 5. Then, my lord, 2062. I'm not reading them, my lord. It's just, my lord. Page 99, my lord, is 206.2.
Yes. Stand applicable Section 8.
Yes, yes. And now, my lord, just another 2 minutes. Kindly, my lord, look at the plaint. Because why I say, my lord, it's a self defeating. Yes, my lord. The plaint at page 502, my lord, it is there. Now, my lord, very important, my lord, their claim, this East Bengal Club against, my lord, 1 and 2. Now, my lord, 1 and 2 are both parties to the arbitration agreement. Their claim really, my lord, is against 1. And, my lord, the others have been added as parties against whom, my lord, there are really no claims. Because what they say is, because they have made claim, like for instance, my lord, 3 and 4 are, my lord, the authorities.
Correct.
Before whom a claim has been made. They are not necessarily parties. Then, my lord, 5 to, my lord,
5 to 14.
14 are, my lord, the players.
They are the players.
We are also not concerned with that.
They are the player.
Because they are saying, because this 5 to 14 are made a claim against me before 3 and 4.
Yes.
Therefore, you are liable to pay me. Now, that is why, my lord, I say, and I'll just show just 2, my lord, 3 paragraphs there. Kindly come to, my lord, paragraph 27.
Paragraph 7.
27, my lord. So sorry, page 520, 27.
Yes.
Because 27 to 30, my lord, is, my lord, what their causes. Based on the above clarification, relying thereon, the plaintiff on July 15, 2020 gave its consent to the execution of the termination agreement as circulated. Correspondence exchanged during the aforesaid negotiation discussions were sent by the plaintiff from his office, such. Then 28. Final termination agreement was executed on July 17, 2020. Copy of the same is annexed here to and marked R. Aforesaid termination agreement was entered into plaintiff's office and answered within the aforesaid jurisdiction. Then, my lord, they say, to further signify that there was no natural continuity of contracts entered into by the defendants. Number 2, the agreement in Schedule 1, Part A, Clause 3C contained the condition that players who had entered into contracts with the defendant 2 would have to execute fresh agreements with the plaintiff in the event the plaintiff wished to retain their services, and such player would have to obtain no objection from the defendant 2 besides execute a mutual termination agreement. Then, my lord, 29. It was thus understood and agreed by and between the parties, plaintiff and the defendant 1 and 2. Again, my lord, in relation to that agreement, that any prior proceedings instituted while the defendant number 2 was running the operations of the club stood resolved, and or the plaintiff was sufficiently protected and or indemnified by the defendant numbers 1 and 2 against the possibility of any claims arising therefore. It was thus expressly and or impliedly agreed between the plaintiff and the defendant number 2 that if any proceedings were to arise subsequent to the aforesaid date of termination, and if any liability were to accrue subsequent to the aforesaid date of termination in respect of any contracts entered into by the defendant 1 and 2, or in respect of any action taken by defendant 1 and 2, in respect of the club sporting activities, plaintiffs would not be liable for the same, and the defendant numbers 1 and 2 would be liable for the same, and the plaintiffs should indemnified to such extent by the defendant numbers 1 and 2. Then 30. Notwithstanding the aforesaid representation and or assurances, there were no outstanding dispute between defendant 1 and 2. The East Bengal club's players and our coaches and our staff members and as well players and our coaches and staff members since the last 1 year. Plaintiff has been shocked and surprised to receive diverse monetary claims from former players and our coaches, including the defendants 5 to 14. Such claims have been sent by players and coaches, including defendants 5 to 14, from outside the jurisdiction. Such claims have also been lodged, filed by concerned parties before various governmental and sporting authorities, including defendant numbers 3 and 4. Herein, outside jurisdiction, plaintiff is not liable. This is one of the crux of their suit. Plaintiff is not liable to make any payment to any of the aforesaid defendants, inasmuch as inter alia there is no privity of contract between the plaintiffs and such defendants for the defendants 1 and 2, had agreed to accept such liabilities, if any, and had indemnified the plaintiff to such extent. Defendants 1 and 2 are bound by law to make such payments to the defendant numbers. Make such payments to the defendants. Copies of some of the orders passed by defendant numbers 3 and 4 and authorities against the connection with claims. This is my lord the S, my lord, which I had shown. Then my lord, just see one more paragraph and I'll be, my lord, done, my lord, with the 44. Yes, very important, my lord, page 531. So paragraph 30, 31 and 44, my lord, 44 and 45. These are, my lord, the crux, my lord, how, my lord, their case really, my lord, gets. A specific representation was held out by the said defendants that there were no outstandings on account of contracts with players and coaches and staff members. Had it not been for this representation, plaintiffs would not have agreed to enter into the aforesaid termination agreement and or clause 4.4.b of the termination agreement as had been drafted by and or at the behest of the defendants 1 and 2. Plaintiff would not have agreed to execute the termination agreement without the defendants 1 and 2 defraying the liability towards defendants 5 to 4 and any other person who may have a claim against the defendants 1 and 2 or plaintiff in respect to defendant 1 and 2 action. It is evident from the foregoing clauses 4.4.b of the termination agreement dated July 15, 2020 does not extend to the claim of defendants 5 to 4. Defendants 1 and 2 are liable for all such claim costs in connection with the claims of defendants 5 to 4. In view of this statement, but with the great respect, but it does not now lie for them to say that we will proceed with the suit and not go to arbitration. Because this is directly on a question of interpretation
of the clause 4.
Correct. That's why, my lord, prayer B becomes red.
As per
Correct.
24.
They're saying, sorry, you gave us some representation, that's on merits. You gave us some representation, we would not have entered into this clause at all. So according to them, clause 4.4.b does not apply to the claims which have been made by the players.
When the claim was made, that is after the agreement.
Yes, I've shown those, Mullah. That's why I showed Mullah page 400.
2020.
Correct.
And this suit was filed?
Well, the suit was filed in 2021. So I'm only on that issue. I'm saying, Mullah, whether the clause binds them, not binds them, whether these claims come under the clause or not, perhaps this court will not decide. This court will say it's an interpretation of the arbitration, it's an interpretation of that contract which has an arbitration agreement. You go there. You may succeed, you may not succeed, but I'm not going to really waste the court's time to look into this when you've agreed. So, Mullah, this is our submission on that basis that, Mullah, kindly, Mullah, refer, Mullah, this disputes to arbitration. And why I showed, Mullah, the cost title is because the others are unnecessary parties. Today, quite naturally, they wanted to get out of the arbitration. That's why, Mullah, they've added them as parties. Because authorities have nothing. The claims have been made before them. Your crux of your matter is paragraph 30, 31, 44, 45, where you say these claims don't come under clause 4.
Under that clause.
Yes.
If that clause remains, they
Correct.
are bind.
Correct.
They are
Absolutely.
binding on.
Absolutely.
That is.
Mullah, I'm so grateful, Mullah. Those are submissions, Mullah. I don't think, Mullah, I need to trouble my lord further on
Yes.
this issue.
My lord, I beg to appear for the plaintiff. My lord, so far as the plaintiff is concerned, my lord, the perspective is slightly different, my lord. Because my lord will bear in mind a few things, my lord, in our humble submission. First, my lord, we are not at final hearing of the suit. So the merits or demerits of the case is not something which, so far as the plaintiff is concerned, we are reserving on our rights on that.
Court is also going to decide. The court is also going to decide whether the arbitration clause is applicable to you and it should be referred.
Secondly, my lord, all the arguments that have been made are, in my understanding, maybe my understanding is incorrect, are on the question of whether the dispute between the defendant number 1 and the plaintiff is arbitrable or not. As if the defendant number 1 and the defendant number 2 are the only defendants to the suit. But that is not the place from where we are coming. Our submission...
That the court is to be examined with regard to the defendants which have made, whether that are the necessary party.
Yes, my lord. So our submission is, my lord, when there are non-parties to arbitration who are also defendants, the court, my lord, in our humble submission will look at whether the cause of action against those defendants can be bifurcated from the cause of action against a defendant which is party to the arbitration.
Okay.
Now, my lord, in that light, my lord, I would like to show the section 8 affidavit in opposition and also parts of the plaint and some judgments. Would your lordship take it up today or some other day as your lordship may please?
Non-commercial. So suffering for the plaintiff, suffering for the defendant number 2. Defendant number 2 has filed an application being GA2 of 2021, GA2 of 2021 under section 8 of the Arbitration and Cancellation Act 1996 for referring the parties to the arbitration. Counsel for the defendant has argued the matter, concluded his argument. Due to paucity of time, counsel for the plaintiff could not argue the matter. According case is adjourned, let the matter appear on Come 19th June at 11:30.
Grateful.
Well, can it be in the 12:30, my lord? Can it be 12:30?
12:30. Okay, 12:30.
Most grateful. Most great.
probate proceeding by the executor, to protect the property. So,
What is the urgency?
Property is being trespassed upon, my lord, 5 acres of land.
Against whom
Open
you-
from all sides.
Is a contested?
No. So where some protective order is there, this is the estate. Your lordship can understand. This is a situation in Bengal which is we are not being able to. Not a small portion of this is becoming, without a certain protective orders of your lordship's court executable. If this is the estate of the deceased. So it's protection, some order is necessary. Any day convenient to your lordship, next week.
Tuesday.
Grateful, deeply obliged. This is the number. A number ta likhe diyeche. Deeply obliged.
Yes.
Item number 1. Minute time for the petitioners.
Yes.
2 corrections are there in paragraph 4. The total amount, instead of 41,30,000, it would be 41,50,000.
Order dated?
Order dated May 7, 2025.
41,30,000.
Instead of 41,30,000, it would be 41,50,000.
50. 50.
It would be evident from page number 55 of the report.
Written?
Hello?
Page number 55
Of the report.
report.
Compliance report filed by the petitioners.
55. $41.50. 41.50. Then
And another one is the date of deed of conveyance. Instead of 3rd May, it would be 3rd March 2025.
March. Yes, that too. So offering for the petitioners. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for correction in the order dated 7th May 2025. Counsel for the petition submitted in the order dated 7th May 2025 at paragraph 2, line number 3. The amount is to be read as 41,50,000. 41 from 50, 000 instead of 41,30,000. And in line number 5, the date is to be read as 3rd March 2025 instead of 3rd May 2025. Considering the submission made by the counsel for the petitioner, peruse the record in the order dated 7 May 2025 at paragraph 2, line number 3. The amount shall be read as 41,50,000 instead of 41,30,000. And line number 5, the date shall be read as 3rd March 2025 instead of 3rd May 2025. This order may be incorporated with the order dated 7th May 2025. Yes.
Lord, on 2nd May, Lordship was pleased to pass directing us to file a supplementary affidavit. My Lord, most of the records are in Gujarati. We have put it for translation. My Lord, Lordship will kindly grant us 4 weeks time to file this supplementary affidavit. My Lord, I am praying for 4 weeks time to file a supplementary affidavit. My Lord,
Of the record of rights.
Records of rights, those are in Gujarati, my Lord.
Not yet been translated.
No, not yet been translated, my Lord.
You are appearing for?
For the defendant.
You are supporting all. Constitution suffering for the plaintiff, constitution suffering for the defendant, counsel for the defendant prays for 4 week time to file supplementary affidavit by disclosing the record of rights. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 18th July 2020. Next, 18th July. Next.
Testamentary matters. Item number 3. My lord, in this matter, I appear for the applicant. My lord, this is a matter for letter of administration where the deceased died on 14th August 2014. My lord, thereafter, the second class of legal heir as applied for the letter of administration before this honorable court. To support my case, I have given a geological chart, which is at page number 10. My lord, I think the petition is not paginated. After page number 9, there is a death certificate as annexure A. Along with the death certificate, I've given a geological chart.
Kitish Chandra Das Gupta.
Kitish Chandra, I have applied for the letter of
this is a
administration of Abhijit Das Gupta.
genealogical chart. Kitish Chandra.
The Abhijit Das Gupta is the deceased over here, my lord.
Abhijit Das Gupta was,
Abhijit Das
he was unmarried.
Unmarried.
Correct.
Mother predeceased.
Huh? Mother?
Death certificate is also annexed as
Was
annexure C.
predeceased to the Ajit Das Gupta.
Yes, my lord.
Then
Death certificate is given as annexure C.
see, wife is there. Who is? Acha, wife of Somesh, yes.
Yes. So only two brothers who are till date alive is Shantanu Das Gupta and Sanjay Das Gupta. Shantanu Das Gupta has given consent.
Where you
And
found the Santanu? Santanu is there.
Shantanu Das Gupta and Sanjay Das Gupta is the cousin brother of Abhijit Das Gupta.
So they are the branch of Satyash.
Yes, they are the branch of Satyas Das Gupta.
Correct.
So both are the only legal heir of the deceased. One has given consent. The consent affidavit is at page.
Who has given consent?
Shantanu Das Gupta has given
Shantanu
consent.
who is the petitioner here?
Petitioner is Sanjay Das Gupta.
Sanjay is the petitioner.
But petitioner is Sanjay Das.
It is a letter of administration
My lord, it's a letter of administration.
or probate.
No, my lord, it's a letter of administration.
What
Because
about the other legal heirs?
there is no other legal heir, my lord.
Wife died. Kitish Chandra wife died.
Wife
having three sons.
having three sons.
Satyash Das Gupta, Sitesh Das Gupta, Somesh Das Gupta.
Sitish was unmarried.
No, Satyash is having died on.
Died on.
Satyash has three sons, two sons, one wife.
One wife.
Wife also died.
Died.
Two sons.
Two sons.
And Sitesh unmarried.
Unmarried.
And Isulas. He died.
And Shomesh died in
Somesh
2000.
died.
leaving
Somesh had two wife and son.
wife and son.
Somesh died. His wife is died.
Died.
Son has also died now.
Son has
So only the Santanu and Sanjay.
Shantanu and Sanjani is alive.
They are the legal. Yeah. So what do you want?
Madam, the letter of administration.
What is the urgency?
Madam, the urgency in this matter is that Sanjay Das Gupta's daughter, who is pursuing higher studies, my lord, is in great need of the finance of the estate. And they are the caretaker of Ramakrishna Mission. My lord, it's already recorded in the earlier order, if you see.
The property belongs to whom? Kitish?
Abhijit Das Gupta.
Kitish.
Abhijit Das Gupta.
No, the property is recorded in whose name?
Abhijit Das Gupta.
Abhijit.
Abhijit Das. Because the cooperative society's property, the nominee gets the property. So it was transferred in name of Abhijit Das Gupta. And the bank accounts and everything is in the name of Abhijit Das Gupta.
Where is the what is the GA2?
GA2, my lord, was for
Disposed?
amendment, disposed of, was for amendment of affidavit of asset because there was a locker. So the receiver was appointed. And when the receiver went to the bank, they only found 100 rupees note inside the locker. So
Where is the affidavit of consent?
affidavit is consent. Annexure D, my lord. Annexure D is not paginate. Affidavit of consent. And the court fees have already been given.
Court fees paid.
Paid. Annexure F.
Where is the description of the property?
In the asset, my lord.
Affidavit of assets.
Affidavit of assets, amended assets, and earlier annexure B.
Where it is?
Annexure B is just
A is the valuation. That
just after the geological chart is annexure B. It should be ideally
affidavit of assets on
13.
bank term deposit. Landed property.
There is property also, my lord. I
Property in
showed
private
in
company.
table serial number 5 in immovable property.
Immovable property.
And there are few bank accounts which have around and few term deposits.
Concession suffering for the petitioner. Petitioner has filed the present application. Who is the petitioner?
Sanjay Das Gupta.
Petitioner has filed the present application for grant of letters of admission to the estate of the deceased. Abhijit Das Gupta, who died on
14th August.
14th August 2024.
In August 2014.
14th August 2024. 2014. 2014. The petitioner is the cousin brother of the deceased. The another cousin brother of the deceased, namely Santanu Das Gupta, has filed an affidavit of consent stating that he has no objection for grant of letters of admission to the petitioner. It is found from the genealogical table of Kitish Chandra Das Gupta. Kitish Chandra Das Gupta had three sons, namely Satyas Das Gupta, Sitesh Das Gupta, and Somesh Das Gupta. Satyas Das Gupta died on 11th of February 1977, leaving behind two sons, Santanu Das Gupta and Sanjay Das Gupta, and wife of Satyas Das Gupta was predeceased to Satyas Das Gupta, who died on 14/11/1976. Sitesh Das Gupta was unmarried and issueless, and he died on 22nd January 2011. Somesh Das Gupta had one son, namely Abhijit Das Gupta, and wife of the Somesh Das Gupta was predeceased to Somesh Das Gupta. Somesh Das Gupta died in the year 2004, and the wife of Somesh Das Gupta died on 23rd October 2001. The Abhijit Das Gupta died on 14th August 2014, and thus the only legal heirs are the Santanu Das Gupta and Sanjay Das Gupta. Sanjay Das Gupta is the petitioner before this court, and the Santanu Das Gupta has filed this affidavit of consent stating that he has no objection for grant of letters of admission to the estate of the deceased. To the petitioner. Had the learned counsel for the petitioner peruse the materials on record, this court find that there are only two legal heirs. Out of two legal heirs, one legal heir has filed the present application, and another legal heir has submitted his no objection consent affidavit. Accordingly, the petitioner is entitled to get the letters of admission in respect of the estate of the deceased Abhijit Das Gupta, subject to furnishing personal bond of rupees 6 lakhs with two sureties.
One surety, my lord, he doesn't.
With one surety. The department.
If the amount may be
The department is directed to issue letters of admission on compliance of all formalities.
Much obliged.
PLA number so this board. Next.
My application, your lordship had passed an order on 26th of February, 26th of March 2025, where your lordship had directed publications to be made. One of the properties being outside. Pursuant to that, publication has been done. We have also filed an affidavit of service. The only thing which is awaiting is a report from the department, and thereafter your lordship can grant appropriate.
I'm passing an order to let the report be filed within a week. Please be heard. So why you are not applied for?
We have only perhaps something with the department. The report has not yet been ready. Any day, any day convenient to your lordship next week. Otherwise, The difficulty is that the beneficiary is wife of the
So appearing for the petitioner. Counsel for the petitioner submit that in terms of the order passed by this court dated 26th of March 2025, the petitioner has taken appropriate steps for publication of the notice in the English daily newspaper, the Hindu, as well as in Tamil newspaper, Tanti, T-H-A-N-T-H-I, Tanti, at Coimbatore.
Yes.
Full stop. Though the petitioner have published the notice, but the petitioner has not received any intimation whether any caveat has lodged or not after the publication of the notice. Accordingly, counsel for the petitioner prays for a direction upon the department to submit report whether any caveat is filed on after the publication of the notice. In view of the submission made by the counsel for the petitioner, the department is directed to submit report whether any caveat is lodged by any of the person after the publication of the notice in the Hindu daily newspaper and the Tamil newspaper in terms of the order dated 26 March 2025 by 20th June 2025. This is the matter on 20th June.
On 20th June itself.
Under the same heading.
I'm great. I'm so grateful.
Next.
Item number 5.
Not today.
I appear for the petition. I'm sorry, my lord. I appear for the petition. I'm so sorry, my lord. My lord, this matter your lordship had been pleased to take up earlier also, and your lordship had been pleased to direct the personal presence of the contemners. Lordship recollects this is a property in Howrah, where in spite of an order of injunction, the alleged contemners claim to have bought the property in spite of having noticed that there's an order of injunction subsisting, and then they started construction. So on the last occasion, my lord, they gave an undertaking to your lordships, my lord, that they will not carry out any further construction and remove whatever they've set up at the premises in question. That also has not been complied with even today. Last day ka order dikhaiye. Your lordship sees, kindly take the order of the last date.
13th March order?
Yes, please. The order don't.
Nobody is appearing for the contemners.
No, man. They filed their affidavits, and my lord, from the affidavit, they've made palpably false statements on note in the affidavit to justify that they are not in contempt. There's no remorse, there's no apology, and on the contrary, there are false statements made on oath.
Have you filed a reply?
They filed, my lord, yes. My lord, they've served us. I don't know whether it's been filed in court, my lord.
Affidavit filed हुआ क्या? The reply to this.
Yeah, तुम order दोगे क्या? सपना देख रहे हो?
Yes. So other party is not here.
My lord, kindly fix a date, my lord. We'll give them notice because in their absence, I don't want to do the matter again, recalling, and it's just a waste of your lordship's time, my lord. Kindly give us a date and time, my lord. I'll give them notice.
So suffering for the plaintiff. None appears on behalf of the alleged contemners. For the interest of justice, this court find that this contempt application is to be heard in presence of the alleged contemner, and as such, for the interest of justice, the case is adjourned. Let the matter appear. कब होगा? 4 July, 4th July, 4th July, the same time.
4th July, man, nothing this side of the. We were only on 13th of July. And Fridays, if your lordship take
27th.
27th, please, my lord.
27 July. June.
27th June, sorry.
27 June. It is made clear that on the date fix, it is made clear that if on the date fix none appears on behalf of the alleged content number 2 and 3, the application will be taken up for hearing in their absence.
Grateful.
Next.
Sir, I appear for the petitioner, my lord. This is a contempt application.
My lord, I appear for the respondent number 2 in this matter. Seeking for your lordship's pardon to appear virtually in this matter, my lord.
Yes, allowed.
My lord, I am for the contempt number 1. Devajyoti was leading this matter.
My lord, as per Lord's,
Third contemner. Huh? Number 3.
In terms of my lord's last order dated 27th March, no amended copy has been served upon us till date, my lords. That is what I've been instructed from my advocate on record.
I have been served
Wait.
copy of the amended copy has been received.
we have done service on 3 advocates, my lord. Advocate appearing for the contender number 1,
I
contender
have
number 2, and
already
contender
received.
number 3.
You are appearing for whom?
For the respondent contender number 2, my lords. In
Yes.
that event, I do not join any issues. Pleadings are complete, my lord. We can continue with the hearing.
Yes.
We have made service. We've completed service on the 3 advocates, my lord.
Yes.
My lord, here, my lord, I will actually be taking time, my lord, because I was led by Mr. Ritoproto Mitro. He's been elevated, my lord. So I was praying that if it
Will
could
not come.
right, my lord. My lord, so if it could be fixed anytime, my lord, we can come back ready with the matter, my lord, and finish it. Pleadings are complete.
So appearing for the petitioner. So appearing for the alleged content number 1. So appearing for the alleged content number 2, and so appearing for the alleged content number 3. It is informed by the learned counsel for the respective parties that the pleadings have been completed and matter is ready for hearing. In view of the above, let the matter appear on
Okay, my lord.
4th July.
Very well. We'll come back.
Grateful, my lord. Grateful.
Wait.
Next.
Item number 7.
I am for the alleged contender number 2, my lord.
Oh.
The petitioner has not appeared even on the last date, my lord. Even the main proceedings has also been dismissed for default. This
What
is
you have done in the contempt?
the learned advocate of my client is a contemner. The special officers appointed by this court are
also
contemners. Contemners, they say that we had to give rent receipts. We have given 3 rent receipts. According to the petitioner, they are forged. And we have not given entirety of the rent receipts. In fact, I'll just
So appearing for the alleged content number 1 and
2,
2.
my lord.
Only 2.
2.
Not 1.
Today I have
the alleged
authorized.
content number 2. What is the good name, sir?
2 is Shoptush.
Your good name?
Shona Ghosh, my lord.
No. Yes, sir. Earlier occasion you appear for both 1 and 2.
My lord.
Not appearing.
I have instructions only
Okay,
for 2. my lord.
so appearing for the alleged content number 1, content number 2. None appears on behalf of the petitioner as well as the alleged content number 1.
No, I have authorization for 1 and 2. I'm sorry, I'm just been informed.
Alleged content number 1 and 2. None appears on behalf of the petitioner. It is fine from the record. The matter was listed on 31st of July 2023, 11th of September 2024, and 12th of March 2025. But the petitioner failed to appear before this court on each of the occasions. But for the interest of justice, the case was adjourned. Today also, when the case is called, none appears on behalf of the petitioner. This court finds that the petitioner is not interested to proceed with the present proceeding. Accordingly, CC 55 of 2023 is dismissed for default. A rule, if any, issued is discharged. Yes.
Item number 8.
8 and 9, my lord.
These are connected matters. I appear for the petitioner in this matter, my lords. This contempt petition has been filed at my instance. Your lordship will recall the matter wherein the directorship in my company had been surreptitiously changed, and unidentified individuals, my lords, they had hijacked my company, wherein your lordships had granted an interim order in my favor on 3rd May 24. Thereafter, my lords, they have continued in violation of your lordship's interim order to further change directorship of the company, my lords. All these records I have brought on notice, my lords. Now, my lord, if your lordship kindly has your last order dated 13th March 2025, there are 10 contemners altogether, of which contemner number 10 is the only contemner who's failed to appear before your lordship despite your lordship's repeated directions, my lord. So in these circumstances, your lordship had issued a warrant against the contemner number 10, my lords. on the basis of the two addresses that the petitioner was able to cull out, one from the Aadhaar card and the other from the Ministry of Corporate Affairs records, my lords. In terms of this last order dated 13th March, your lordship had also directed the petitioner to file a supplementary affidavit bringing on record the document that the petitioner is in possession of, on the basis of which the address can be culled out and the father's name of the correspondent contemner number 10 can be ascertained. Because, my lords, the police station at Bihar, they said that they're not being able to identify and get hold of this person because the father's name is something that is unaware of. So, my lords, the respondent number 10 had filed an affidavit in opposition to my contempt petition. In that affidavit in opposition, the respondent number 10 had also annexed his Aadhaar card. So we've brought that on record. If with your lordship's leave, my advocate on record is there, she'll hand over a copy of the supplementary affidavit that we've prepared, my lords, for your lordship's kind perusal.
This is a copy of the supplementary. However, my lord, there is a small correction. I'm praying leave to delete one line, my lord. This has come.
My lords, I'll just refer to one document, my lords, in this supplementary affidavit for the time being. If your lordship kindly has, my lord, the Aadhaar card that is there, this Aadhaar card, my lord, has been annexed at page 29, my lord.
Yes.
Your lordship will find that unlike other Aadhaar cards, this Aadhaar card does not contain the name of the father of the respondent contemner number 10. It just only contains the address, my lords. So we ourselves have not been able to ascertain the father's name of the respondent contemner number 10. And he's failed to appear before your lordship, my lord.
My lord, although my learned friend is making submission, my lord, at page number 25, the name of the father name is appearing as Mazrul Hassan, and also it is my mistake only. And the Aadhaar card also in the at the back side of the Aadhaar card, my lord, it has been it's Mazrul Hassan. I think it will be Sanaf. It's written O only.
Oh,
yes.
correct.
I am under.
Where from you got this copy?
This Aadhaar card has been annexed to the affidavit in opposition filed by this contempt number 10 in this proceeding. That is why I have annexed the entire affidavit in opposition. It is starting from page number 23. So from there, I have got hold of the
Where is the affidavit? His affidavit?
23.
Affidavit portion?
Well, kindly come to page number 25.
25. Is Azaz Ahmed?
Yes, ma'am. He is not appearing, my lord.
No, what is his name?
Well, Azaz Ahmed. Well, can you see?
Ijaz Ahmed.
Yes.
Azaz Ahmed. AJAZ.
Yes, my lord.
Yes, my lord.
Telling you Mazrul Hassan.
Yes.
Son of Mazrul. Yes, it's the same name. It is appearing in the affidavit
Yes,
portion.
my lord.
Yes, ma'am.
Terms of business residing Asdar Jammu. Jamui.
Jamui, Bihar. And
what is the report? Have the notice has been sent on this address?
No, my lord. That is why this has been, the notice has
Earlier
been sent to
notice
this
was-
address, my lord. But then he could not be identified because of the non-availability of the father's name.
No, whether पहले का report था ना?
On March 13, 2025, I think the report of March 13, 20. Superintendent of Police, Jamui, Bihar. Sir, if my lord kindly looks at the order dated March 13, 2025 at page number 2, my lord has
No, that's I wanted to see the report.
report I don't have, my lord. It is always with the copy.
Hey. Take a speaker report. रजिस्टर कंपनी नहीं एसपी का था ना। You persons are taking the order from this court and not going to the office and not submitting your proper. Last occasion I passed an order. You have given the warrant. You are not giving the warrant. What the warrant is issued by the department, that is. You are not going to the verifying the what warrant they are issuing, whose name, what address.
Address was furnished by us. My lord kindly takes up my affidavit. I have already indicated at page number 12 that the address that I have furnished.
Yes, without the name of the father, it cannot be. So this is the name.
This is the name, my lord. And also there is a photograph also, my lord.
One kind indulgence, but I am representing the alleged contempt numbers 1 to 7, except for the alleged contempt number.
You also appear for the 10.
10, I don't have instructions, and he's
Yes,
not
yes.
not my
What
client.
what is your submission?
The only thing we had entered appearance, but thereafter we had asked for the cost papers. Since we don't have the cost papers, we have
I am
sent
not my cost paper has all the marking and everything, my lord. Let them take out a certified copy, my lord.
at our cost. We wanted that. That is,
you have to file the compliance report.
Well, compliance report they have filed. Matlab
Where they filed?
Well, they have filed their opposition, my lord. Everything.
You filed the
I since
Your
we have-
advocate
we
on
have-
record has.
this is a change brief. We do not know for
That
which
is
we
the
have.
problem.
We have sought for the cost papers from her.
What cost paper? What cost paper you want?
The petition and the affidavits, my lord, whatever.
You are not having.
I am having, my lord, but those are marked, my lord, heavily.
At my cost.
My advocate.
She has marked, then he will take the advantage of the mark which she has done in the petition. So what will happen?
We will take out certified copies.
So appearing for the petitioner. So appearing for the alleged contender number
1 to 7,
1
except
to-
for 3, my lord.
1 to 7, 1 to 4, 1, 2, 4, 2, 7. You are not appearing for the 9.
No, my
lord. Somebody is appearing for the 9 today. Nobody is there. Full stop. Counsel for
So, Mr. Arijit
submit
Sarkar
that
was appearing, my lord.
earlier the warrant has been issued against the alleged content number 10, namely Azaz AZAJ Azaz Khan, Katua KAW Katua road में देखे मार देना. But the superintendent of police Jamui, Bihar had submitted the report that without the name of the father of the contender number 1, it is not possible for the police to execute the warrant, as there are several persons in the name of Azaz Ahmed are in the village Jamui. Today, the petitioner has filed supplementary affidavit disclosing the affidavit in opposition. What you are
Affidavit in opposition, my lord.
affidavit in opposition filed by the alleged content number 10 in the present proceeding.
In the present proceeding, my
In
lord.
CC number 77 of 2024, wherein the alleged contender has affirmed his affidavit by giving his description as follows. This one. Page 25. This one. The petition has also enclosed the copy of the Aadhaar card wherein the same address is appearing. In view of the above, the petitioner, the office is directed to issue fresh warrant to issue fresh warrant upon the alleged content number 10 by disclosing the name, father's name, and proper address and the superintendent of police Jamui, Bihar is directed to execute the warrant and to file the report by the next date fix. List the matter on 18th July 2020.
There's one small correction that I have to do in the affidavit. I'm praying for a small.
And उससे पहले आएगा ना?
Typo.
Supplementary affidavit filed by the petitioner be kept with the record. Huh? Yes.
There is a small correction, my lord, at page number 13, my lord. There's one line that has gone. 13, my lord. 11 paragraph, my lord. It is relevant to mention the Aadhaar card does not record the name of the content number 10. My lord, this will be deleted, my lord. This has gone.
Counsel for the petitioner prays for leave to delete the sentence appearing in paragraph 11, page number 13 of the supplementary affidavit, which reads as follows. It is relevant to mention that the said Aadhaar card does not record the name of the alleged content and the said content number 10. Police shall not come across. The petitioner is given liberty to delete the said sentence and to put her initial after the
And I'm also filing my
of
affidavit.
the said sentence.
I'm also filing my affidavit of reply to their affidavit.
Affidavit of reply to the affidavit in opposition filed by the other contemners be kept with the record.
May I be favored with a copy of this reply and a supplement?
Give the copy.
Grateful, my lord. Grateful.
Next.
Number 10.
My application, my lord, I had completed my arguments, my lord, that Ravi Sanai matter. My learned friend, Mr. Mikro, was addressing your lordship.
What is the point?
My lord, your lordship will recall, my lord, that orders were passed on 2 consecutive days, my lord, restraining them from making any transfers, and my lord, they have gone ahead and gifted. And my lord, those, and thereafter they have aggravated the contempt by my lord issuing letters to the my lord society.
No,
Yes, sir.
I had made some submissions before your lordship, but my lord, may I? I really do not know, but I don't remember anything.
Now you have referred all the. Okay, no problem. You can.
Now,
argue today or?
No, I can. My lord.
Yes.
Now, my lord, as I submitted before your lordship, my lord, here, my lord, the son, the younger son, my lord, of course, my lord, is trying to uphold the dignity of the court by trying to, my lord, send the parents to jail. There is no difficulty there. Now, kindly look into, my lord, kindly come to, my lord, page 19, my lord, paragraph 27, my lord. What were
you have draw the attention of this court to paragraph page 19, page 50, page 323, page 39 of the contempt application, page 337, 339, and 341, paragraph 48, 49.
No, my lord, to be very candid, my lord, I don't remember.
Section 32 of the Registration Act, 32C, 34(2)(3), Section 35 ABC, AB and subclause 2, Section 52, 58, 59, 60, then page 150, dated 18th July 2024, page 152, then page 154, page 185, 186, 191, and 223 order dated 18th October 2024. This up till this you have brought to the notice of
Order dated
8th October 2024.
সেটা কোনটা রে? 8th October. No, my lord, then in that event, my lord, I really do not want to, my lord, again.
Yes, 8th October 2024.
My lord, only my submission before your lordship was, my lord, that the day, my lord, the registration was done, my lord, the order was not there. The order was passed subsequently. It's not their case, it cannot be their case that, my lord, I have executed the deed of convey, the deed
Yes,
of
you have shown the procedure already initiated.
Deed of gift in violation of the court's order. Now, my lord, in that event, my lord, they have possibly relied on 2 decisions. May I try to, or 3 decisions possibly. Okay.
Yes.
My lord, the first one, my lord, they have relied on is possibly reported in 2006, Volume 1, Calcutta Law Times, page 355. No? Kuda?
They have relied upon 2017 Volume 1 SCC 599, 2017 Volume 2 SCC 456.
Lordship, my lord. And
another one is 2003 SCC Online Calcutta.
2003.
This 3 has been given to me.
Yes, powers of court are in contempt, that it can also, my lord, pass directions undoing the wrong that has been done.
2006 Volume 1 CLJ. That copy has
Yes,
not been
2006
provided.
Volume 1 Calcutta Law Times 355.
The copy has to be provided.
My lord,
Now, my lord, kindly take this, my lord.
Yes.
Kindly come to, my lord. I would like to place a few paragraphs of this judgment, my lord. Kindly come to the first paragraph, my lord. I hope, my lord, I sincerely hope that, my lord, the paragraphs tally, my lord. First paragraph would definitely, but thereafter I'm not very certain. My lord, first paragraph, my lord. This contempt application has been filed by the petitioner alleging willful and deliberate violation of the order dated 5th August 2003, passed by this court by so-and-so number such and such. On 5th August 2023, this court, upon hearing the parties, was pleased to pass the following order. Heard counsel for the parties. The order of the tribunal against which this application has been filed could not be annexed, as according to the learned counsel for the petitioner, he is not able to obtain the copy of the same. Therefore, adjourn the matter till such and such. Let the next paragraph, next sentence. We hope by that time the order impugned in this writ application will be made available to the petitioner. Let the matter appear on such and such date. Parties are directed to maintain status quo as on date till next Thursday, that is 12th August. In the facts and circumstances of the case, a Xerox copy, etc., it's not required. Now, my lord, kindly come to paragraph 20. My lord, if it starts with in the contempt petition. In the contempt petition, the main grievances are that after the order of status quo was passed by this court at 12:30 p.m. on 5th August 2003, the alleged contender number 1, with full knowledge and notice of the order, issued an order in favor of the alleged contenders number 1 and 2 at about 5 p.m. on 5th August 2003, and as such, the order of promotion was passed in willful violation of the interim order of status quo dated 5th August 2003. It is stated in paragraph 26 of the contempt petition that the said order of promotion was passed to overreach this honorable court. Then, my lord, kindly come to paragraph 25. The alleged contemptor number 1, however, has not denied that the interim order of injunction was communicated to him between 2 p.m. to 2:30 p.m. on 5th August 2003. This has been specifically averred in paragraph 20 of the contempt petition, and in paragraph 12 of the opposition filed by the alleged contemptor number 1, this has not been denied. Apart from that, a close scrutiny of the stand taken in paragraph 2b of the affidavit filed by the alleged contemptor number 1 also shows that the file regarding the appointment of Sri Pal to the post in question reached his table in the forenoon of 5th August 2003, but it has not been stated that when the notification was signed by him on that date. In fact, it has not been stated by him that the notification was signed by him before receiving the communication of the order of the court. Then, my lord, kindly turn the page. Kindly come to paragraph 38.
Yes.
This court is of the opinion that the standard of proof in a case of contempt must be a strict one, since contempt case must lead to quasi-criminal implication. It is also well settled that the person who alleges contempt must prove it. The court has considered the matter in some depth and finds that a clear case of contempt might not have been made. It is of course true that in a case of this description, where the entire act of contempt, namely passing of the order of promotion by the alleged contemptor number 1 and the assumption of charge by the contemptor number 2, took place in the secrecy of the office of the respondents, and it is difficult for the petitioner to prove that the said act was committed after this court passed the order. Then, my lord, kindly come to, my lord, a few more paragraphs. Kindly come to paragraph 43.
Yes.
Therefore, one thing is clear that after getting notice of injunction from the court, things were rushed in an unprecedented manner by the alleged contemptors. In my considered view, there can be no two opinion about the fact that the alleged contemptors were trying to overreach the court, anticipating the order of injunction. Then kindly come to 48 onwards. This being the position in law, the question is what the court can and should do in the facts of this case. There is ample authority for the proposition that in a situation when the respondent, on getting notice from the petitioner that an injunction petition will be moved before a court, hurries up things in an effort to circumvent the impending court proceedings, or rushes to overreach the court by anticipating its order with a view to stealing a march over the opponent, the court can, in an appropriate case, by issuing an injunction order in a mandatory form, nullify the steps hurriedly taken by the respondents after the notice was received. Reference in this connection may be made to two old decisions of Chancery Division. The first one is Daniel, reported in such and such. In Daniel, the plaintiff objected to the erection of a building upon a piece of land adjoining his property.
That would
materially affect the access of light and air to his property. After some correspondence between the parties, plaintiff decided to initiate an action for injunction and gave notice. Notice of such injunction was served on 5th December 1890, a Friday. The defendant, on receiving the notice, employed extra men who worked overtime during Saturday and Sunday, and by Monday morning ran up the wall up to 39 feet from the ground. Mr. Justice Sterling, before whom the matter came up for hearing, restrained the defendant from further building on the land and also from permitting the wall which he had erected to remain on the land. On appeal, it was argued by the defendant that it is against the practice of court to order a building to be pulled down on an interlocutory application. Lord Justice Lindley, one of the judges in the appeal, held the defendant, upon receiving notice that an injunction is going to be applied for, sets a gang of men to work and runs up his wall to a height of 39 feet before he receives notice that an injunction has been granted. It is right that building thus run-up should be pulled down at once, without regard to what the result of the trial may be. Lord Justice K, another learned member of the bench, referring to the acts of the defendant, held whether he turns out at the trial to be right or wrong, a building which he has erected under such circumstances ought to be at once pulled down on the ground that the erection of it was an attempt to anticipate the order of the court. To vary the order under appeal would hold out an encouragement to other people to hurry on their building in the hope that when they were once up, the court might decline to order them to be pulled down. I think that this wall ought to be pulled down now without regard to what the result of the trial may be. The ratio of Daniel was reiterated in Von Joel, reported in such and such. In that case, the defendant evaded service of notice of injunction and in the meantime went on constructing the building in respect of which injunction was prayed for. But there was no report that extra men were employed by the defendant. Lord Justice Kekwich granted an injunction restraining the defendant from building and also from allowing the building built after date of notice of 24th May 1895 to remain, and there was a direction to pull down that part. In appeal, it was argued that the case is distinguishable from Daniel in that the defendant had no notice of injunction proceeding, he did not employ extra men, nor did he disobey any injunction order. Overruling such contention, Lord Justice Lindley, a member of the appeal court, held the case within the principle upon which the court acted in Daniel and upon which I will always act. The court will not allow itself to be imposed upon a proceeding of that kind. If builders will take the chance of running up a building in that way, they must take the risk of pulling it down. To the extent I think Kekwich was perfectly justified in the view that he took, and this appeal must be dismissed with cost. Then my lord, it goes on. My lord, in my submission, none of this, my lord, this decision, so far as my lord Ranjit Haldar is concerned, there, my lord, the order was there, and my lord, it was communicated. After that, steps were taken. These other two, the Chancery Division decisions, also, my lord, factually, my lord, does not apply in the facts of our case.
Yes.
Now, my lord, the next decision, my lord, kindly take up, my lord, 2017 1 Supreme Court cases, page 599.
Yes. That I think you have given the reply to that.
I had dealt
you
with
relied by paragraph 19.
But did I deal with, my lord, the other one?
Other you can deal with. 2017?
I did not. Very well. Kindly, my lord, take up 2017 volume 2 Supreme Court cases, page 456. লর্ডশিপের তো খুব ভালো নোট নেওয়া রে, তো আমার বলছি খুব ভালো নোট নেওয়া তো।
Yes.
Kindly give me a minute, sir. Let kindly then come to paragraph 32 directly.
Yes.
Here, my lord, the respondent number 1, my lord, to evade an order got himself admitted, and the other respondents, my lord, aided and abetted. My lord, there's a case of aiding and abetting. Kindly come to 32. From the records and the inquiry report as stated above, it is clear that soon after the order dated 24th October 2013 passed by this court, the respondent remained admitted in the hospital for a total of 527 days. Nothing has been placed on record, nor any medical condition or reasons have been adverted to why such admission was required in the first place. As found in the inquiry,
no laboratory test was conducted.
As found in the inquiry, no laboratory test was conducted during the period of admission from 25th February 2014 to 12th April 2014 and from 12th April 2014 to 1st May 2015. This shows that the illness as projected was not serious at all, and no intensive treatment as indoor patient was required or called for. This prolonged admission without any justifiable medical reason was essentially to defeat the direction issued by this court in its order dated 24th October 2013 and repeated non-bailable warrants issued by the trial court. The order passed by the trial court on 20th November 2013 shows that an affidavit of son of the respondent was filed along with a copy of
Yes.
Sorry. A copy of the review petition. The application seeking exemption was rejected by the trial court and SHO concerned was issued notice why the warrant of arrest was not executed. Subsequent orders dated 5th February 2014, 15th March 2014, 16th April 2014 and 15th April 2014 indicate that fresh warrants of arrest were issued through Superintendent of Police. Neither the respondent surrendered to custody as directed by this court, nor the police concerned took any step to arrest him or try to find his whereabouts. No report was made to the trial court. What is evident is total inaction on the part of the police, which helped the respondent in evading arrest and defeating the order passed by this court as well as by the trial court. This callous attitude and conduct of the police calls for strict administrative action and corrective penal measures. The conduct exhibited by the respondent in getting himself admitted in the hospital when there was no medical reason to justify such admission and the continuation to remain admitted till action was taken by this court in contempt jurisdiction exhibits scant respect and regard for the orders and processes issued by the court. Despite issuance of notice, the respondent has neither filed any response nor tendered any apology. Having gone through the records and considered the inquiry report, we have no doubt that the respondent is guilty of having committed contempt of the direction issued by this court in its order dated 24th October 2013 and also in obstructing the administration of justice. This part is important. We now turn to the role of the hospital and medical professionals. The explanation offered by Dr. Munish Prabhakar and Dr. K.S. Sajdev was that they were not aware of any direction by this court to the respondent to surrender to custody or that the respondent was required in connection with any crime. At the outset, it must be stated that the respondent stood admitted in the hospital for 527 days. Not a single laboratory test was conducted during the period from 15th February 2014 to 1st May 2015. The paper produced on record do not in any way suggest any medical emergency which could justify continued admission of the respondent as an indoor patient. Further, during the
Admission of the respondent.
third admission of the respondent from 12th April 2014, the first payment to the hospital was made only on 10th January 2015, that is nearly after 247 days. It is inconceivable that in normal circumstances, a man who has no ailment or a medical condition requiring emergency treatment would be kept as indoor patient without any laboratory test and without recovering a single paise for more than 247 days. Moreover, the record indicates that on as many as 47 occasions during his admission, the respondent was allowed to move out of the hospital without even an endorsement by any medical professional justifying such movement. The inquiry report further shows that there used to be regular stream of visitors during the stay of the respondent in the hospital. These features clearly show that the respondent was in perfect condition of health and never really required admission in the hospital as an indoor patient. The role of the hospital was certainly not as innocent as it sought to be projected, and the features detailed above clearly show that the hospital was party to the attempts on the part of the respondent to defeat the order passed by this court. Now, my lord, as I have said, my lord, the document, the grandparents or my lord, the grandson, my lord, the document was executed prior to the order. It's nobody's case that, my lord, I could have, my lord, violated the order passed by this court.
Yes.
And my lord, submission was possibly made though possibly that's not, my lord, the case of contempt made out. That, my lord, I ought to have stopped, my lord, the registration. Now, my lord, I placed before your lordship the Registration Act, my lord, the provisions of the Registration Act, my lord. It was beyond my hand. I could not have done anything, my lord. It was entirely for the registering officers, my lord, registration office officers, my lord, or the registering authority to do so. My lord, those are my full submissions, my lord. There is no, my lord, violation, my lord, of the order passed by this honorable court, forgetting about, my lord, any willful violation. Okay. And, my lord, as I possibly had pointed out to your lordship, my lord, that after this, the order, my lord, the suit, my lord, it was said that, my lord, this court has no jurisdiction, and now they are, my lord, proceeding. They have filed a suit, my lord, in Alipur court and proceeding there. My lord, those are my submissions.
Come back on another day for reply. Yeah.
Supreme for the petitioner.
My lord, 18 in 2017, one Supreme Court cases, my lord, they had relied on 1819, my lord. We had relied on, my lord, paragraph 14E.
2017? Volume 1.
2017, volume 1, Supreme Court cases 599.
Yes, 1819.
They had relied on.
Yes, you have given the reply to that.
Yes.
Mr. Mitra has cited
By
according to
referring to, my lord, diverse paragraphs, my lord, starting, my lord, from possibly
2, 4,
yes.
13.1, 13.3, 13.4.
referred.
Judge to অনেক আমাকে দিয়েছে না?
You referred the paragraph 1 is starting.
Yes, yes.
Then thereafter 2, then 4, then 5, 6.
Sorry, ma'am. I'm sorry.
7, 9.
Sorry, extremely sorry.
No, it's okay. Suffering for the petition, suffering for the alleged contemner. Counsel for the alleged contemner concluded his argument. Counsel for the petitioner pressed for time to give reply. In view of the submission made by the counsel for the petitioner, case is adjourned. Let the matter appear on 20th June.
The interim order is still today. Interim order is still today, my lord.
Interim order is extended till 20th June 2025 or until further order, whichever is
Gotcha.
Item number 11.
Lord, I appear for the alleged contemner, my lord.
I appear the petitioner, my lord.
Before my learned friend, my lord, moves his application, my lord, one thing, my lord. The copy of the contempt petition which has been served upon me, my lord, was incomplete. I had indicated it to them.
Last time it was
Yes. Now I'll just show, my lord, one document. They had served me again, but my lord, they had served the pages 12 to 14 of another contempt.
My lord, there was an order for service. I have served. My lord, he indicates that there are two
Kindly
three
seize,
pages
my lord.
which are, my lord.
That
incorrect.
contempt, my lord, is regard non-deposit of money, which is not the case in this matter.
A contemner should not be so aggressive, my lord.
I have to be. Yes, filed.
before this kid, the containers are acted in violation of the breach of 30th August 24.
No, that's
There
wrong.
is no such order in this matter, my lord. So I have said,
I'll do this, my lord. I'll give him, supply him those, my lord, 3 correct pages. Let him use an affidavit.
other than that, my affidavit is ready. I would have filed it,
No, but he
since-
would need these 3 pages
Yes.
also. I'll give him, my lord, in course of today. Let him use an affidavit. My lord, in between the same parties, item number 14 is another contempt. Please issue a, my lord, order for service. I'll serve that as well.
Yes, that has not been served.
Item number 11, na?
This is 11.
Suffering for the petitioner, suffering for
Green contempt.
alleged contemner, counsel for the alleged contemner submitted in compliance with the order dated 19th March 2025. The counsel for the petitioner has supplied the legible copy of the application, but after going through the legible copy of the application, it is found that page 12, 13 and 14.
14, my lord.
14 are not connected with the present contempt application. Counsel for the petitioner submitted in course of the day, the correct copy of the contempt application will be served to the learned counsel for the alleged contemner. the contempt is directed to file affidavit in opposition by
My lord, a week, my lord, from
within a week.
not
Reply
week, my lord, kind of 2 weeks. My lord.
2 weeks takes us to 27.
Yes, 2 weeks.
2 weeks. Reply if any
1
that to
week.
be filed within 2 weeks thereafter. This is the matter on 18th July.
18 July. My lord, the serial item number 14, my lord, is another contempt filed by them.
14, kindly, my lord, it's appearing for the first time.
That has not been served upon me.
14 records so and so appearing for the petitioner. You are appearing.
Yes, my lord, I'm
Same
party, same party.
So and so appearing for the alleged contempt.
Service.
Petitioner is directed to serve the copy of the contempt application along with the documents to the learned advocate appearing for the alleged contemptors by
today I will serve. That's
in course of the day.
let him use, my lord, affidavit there also.
That affidavit in opposition we filed
2
by
weeks, my lord.
2 weeks.
Right.
Reply if any that we filed 2 weeks. This is the matter on 18th.
My lord, one last intelligence for today, my lord. Item number 22 again between the same.
No, my lord, that my lord,
No, my lord,
that application cannot be.
That's a modification application of your lordship's order where, my lord, they have filed an opposition. I am out of time by they have served their opposition. I am out of time so far as my reply is concerned. My lord extends the time to file my affidavit in reply, and thereafter, my lord,
best of respect, this application will go before the regular division, my lord.
it's a modification application, modification of your lordship's order.
Yes. My lord, just one more thing, my lord. I have filed an application for extension of time. Extension of time to file written statement, my lord.
In which?
My lord, in this matter only. Before the master, they had objected. Your lordship, I'd be praying, my lord, if
he objected to an order being
if
passed
it is
in item
objected, then
22.
automatically matter will come.
Let us
the matter has been referred. Your lordship. Very well.
Yes, next.
My lord, item 14, I was to file a supplementary. Kindly takes this on.
Item 4 supplementary affidavit.
I'll serve that as well.
Supplementary affidavit filed by the petition be kept with the record. The petition is directed to supply this supplementary affidavit to the alleged advocate appearing for the alleged contemptors, and the contemptors are also at liberty to file their reply to the supplementary affidavit as directed above.
So far as item koto bolun? 22, my lord, he seeks time to file reply, my lord.
I told my lord, he
I'm not, I'm
he only
objecting to the hearing of the application.
Item number
But
22
not
so and so appearing for the petitioner, so and so appearing for the respondent. Counsel for the petitioner prays for extension of time to file affidavit in reply. Let affidavit in reply be filed in 2 weeks. Please the matter on 4th July.
Great.
So on 4th July will be for the regular.
No, 4th. 22. Item 22. Yes. Item 12.
Lord, my contempt petition, your lordship had, my lord, directed twice, my lord, to serve them. Lord, I have served the affidavit of both affidavit of services are here. Today, I believe she is appearing, my lord.
My lord, I am praying for not today on behalf
Whether
of.
you are appearing or not.
Yes, my lord, I am appearing.
Sole contempt, no?
No.
Sole
Con-
contempt.
No, several contemners are there.
My lord, I
appearing for
appear
all.
for contemner for 1 to
Appearing
6.
for whom?
Contemner number 1 to 6.
1 to 6, all.
Yes, my lord.
All, no?
1 to 6.
1 to 6.
1 to 6. What about the 7 to 11? 7 to 13? Service completed?
My lord, yes, my lord. Kindly, my lord, seize the affidavit of service, my lord. Let there be, my lord, warrants be issued. my lord.
কোথায় আছে?
My lord,
Affidavit? दो है.
Lord, orders by your lordship, my lord, directing them to make payments. Only one payment made. Thereafter, my lord, no payments are being made. Plots sold off after your lordship's order. No submission of statement of account.
Yes.
my lord, I am being led by Mr. Orindam Banerjee. He's on legs in courtroom number.
What is your submission?
My lord, I'm not briefed in the matter.
You file affidavit.
Let at least the person whom she is representing, let them file affidavit. But the rest, my lord, let director.
So and so appearing for the petitioner. So and so appearing for the alleged content number 1 to
6.
6. None appears on behalf of the alleged content number 7 to 13. Affidavit of service filed by the petitioner be kept with the record. Counsel for the alleged content number 1 to 6 prays for time to file affidavit of compliance. Let affidavit compliance be filed by 2 weeks.
2 weeks, my lord.
2 weeks. Reply, if any, there to be filed by a week thereafter. Full stop. As none appears on behalf of the alleged content number 7 to 13. In spite of receipt of notice, warrant be issued against the alleged content number 1 to 7 and 7 to 13. Let the matter appear on 18th July. Next.
Item number 13.
This is out of a contempt proceedings. I'll be.
So many contempt.
My lord,
13, my lord.
my lord, there is a further act of contempt. My lord, the interim order which was passed by your lordship, my lord, has been set aside by the division bench. But while your lordship's order was subsisting, my lord, that contempt was taking place. So the contempt is not infructuous if your lordship wants me to rely on decisions. But before that, my lord, a special officer was appointed and he was asked to affidavit of service. He was asked to file a report. May that report be first filed and circulated.
Lord, I have the report, Lord, I'm filing. Lord, one copy I'm sharing.
Other part?
Yes, both the
yes.
Report copy of the report.
Let us just consider the report, my lord, because there is a further act of contempt because they were asked to show cause. If your lordship kindly takes the affidavit of service, my lord, the order passed by your lordship 4th April, my lord, it's at page 10 of your lordship's page 10 of the affidavit of service. My lord, will kindly see paragraph 7. Considering the above, let notice be issued upon the alleged contemners to show cause within 2011 as to why rule should not be issued. They have till date, they have not done it. My lord, will kindly see the affidavit of service, which is at page 12. It was served on 7th of April. This itself is a further act of contempt.
Okay. So appearing for the petition, so appearing for the alleged contempt. Mr. Mito, you are appearing for?
My lord, appearing সবাই তো? For the, my lord, respondents, my lord, I would say the alleged contempt.
Oh, alleged contempt number all?
All but.
Alleged contemptness. Police stop. A special officer has filed the report after serving the copy to the London counsel for the respective parties. Let the same be kept with the record. Counsel for the parties prays for time to go through the report submitted by the special officer. Let the matter appear on 27th. 27th.
I was only praying, my lord, if we can, my lord, affidavit, my lord, we.
No, my lord, this is an act of contempt. They were asked to show cause by.
To file the affidavit.
That is exactly what
They never sought for an extension either.
क्या बोला? Send the copy to the land counsel for the respective parties. Full stop. The counsel for the alleged contempt prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within
10 days.
10 days. List the matter on 11th July. Yes, next.
Item number 15.
Lord, in this matter, may be permitted to appear virtually for the alleged contemners.
Yes.
Lord, what happened in this matter, Lord? The order passed, judgment and order passed by your lordship, and an appeal has been preferred by my client in April 2025. But the appeal and the connected stay petition has not been listed as yet. But I shall be submitting, kindly adjourn the matter for some time.
I'm opposed. My lord, I am carrying, my lord, 3 judgments, one of Supreme Court,
Yes,
2 of our.
But only I am praying, your lordship kindly adjourn the matter for a fortnight. Let the stay petition appear in the meantime. Let us see what happens. Then your lordship kindly direct them to serve me a copy of the contempt application. Well, I shall be addressing your lordship on the next day. Not let the stay petition comes. Not the appeal has been filed on 6th of April 2025.
Till you file the appeal till 12th of May, you had
Yes, I quite appreciate. Lord.
You're
But
not-
my advocate on record is not in station for last 15-16 days. But later he will be coming back today. Monday itself, I understand that he will mention the
I am fixing on 20th.
on
Let matter appear on 20. Next Friday.
next Friday.
Yes.
As your lordship pleases. In the meantime.
So
As you-
opening for the petitioner, so opening for the alleged contempt. As per the prayer made by the counsel for the alleged contemner, the case is adjourned. Let the matter appear on 20th.
But in the meantime, let my learned friends have a copy of the contempt petition upon.
Yeah, the petition is directed to serve the copy of the contempt application along with its document to the learned counsel appearing for the contemners by Tuesday.
My, I am so grateful.
Item number 16.
It's my application for contempt, my lord, is appearing for the first time. I'll tell you, lordship.
Where is the order?
Page 57.
57.
57. And
My order?
Yes, it's my lord's order.
That one?
Yes. It went up for an appeal. Page 61. Dismissed. That one, yes. No, nothing given till date. The documents. Now 61 is the order by which it was at the appeal phase. It has to, yes.
So and so appearing for the petitioner. The petitioner has filed the present contempt application on the allegation of violation of the order and deliberately and willful violation of the order passed by this court dated 16 January 2025 in TS 7 of 2022 in IAGA number 6 of 2024. Let the notice be issued upon the petition directed to issue notice upon the alleged contemner or contemners.
Two contemners.
Contemners. And to file affidavit of service on the returnable date. List the matter on 27th.
Obliged.
Next.
Motion. Item number 17. Water.
This is not a contempt.
For a change.
On my application for leave to examine my witness when I'm for the defendant on commission. The witness resides in Pune. He comes for the hearing. This matter has been going on for a long time, my lord. Only in the interest of expedition, we had made this application. But that was 3 months ago, because my learned friend successfully has managed to take time to file an opposition, only to say that the demeanor is important.
No,
But
not
that
only
submission could
demeanor,
have,
but
that submission could have been made. Like the application, as soon as there's evidence finished, it took 3 years for them to finish this. And we have counted there are only, I think, 13 effective Fridays till New Year's. So, my lord, if the commission is done, it will be in the interest of every person, and we will be paying the bill. He'll come to Calcutta, and he can do it in stretches. So I don't know why my learned friend is taken this elaborate
this
stand.
is, Milord, what is
One
my
second.
objection?
What?
If the witness, Milord, who is residing in Pune.
So you're interested to go to Pune? I pass an order, then
No, difficulty is, Milord,
He's here today
because
also.
we all know, Milord, your lordship is always, Milord, kind enough, Milord, to fix, Milord, the matter when the witness come down, Milord, and depose before this honorable court. So, Milord, if the witness is willing to come down at Calcutta, kindly takes, Milord, note of, Milord, paragraph
Litigation
7.
has been going on from 1987, effectively. They've been coming and going.
We
It's
have
not that
completed our examination in chief, Milord, in 2 days. Milord.
in 3 years.
In 2 days, examination in chief over. Thereafter, cross-examination.
Yes, the bank.
Yes.
Yes.
But
So,
the litigation
bank-related
going on,
matter,
it's not a question
and
of-
Milord kindly takes note of, Milord, the reason. Milord.
It's paragraph 5.
Paragraph 5 and 7.
It is-
7 last paragraph,
It is a lengthy
last line.
witness, Mr. Ghosh. It is a lengthy witness. How much time it
Chief
takes?
again will take maximum 2 days.
2 days.
Maximum. Because it's the history is long. It starts from 1987.
It is a commercial.
And I have a counterclaim as well, so I have to.
It's a non-commercial.
Non-commercial. Non-commercial.
Non-commercial.
Especially as
We have got a decree in our earlier suit. Now that suit, my lord, has been when it went up to the Supreme Court gave the bank an opportunity to file appropriate proceedings if they have a claim. They took leave from the Supreme Court, and allegedly under that leave, we will show that it's not under that leave at all. Then now the evidence is very clear it is not. So my decretal dues have been deposited in this court. At least if it's going to be delayed, then let me take back my deposit at least, because I'm out of this, my fixed deposit, a 20 lakh fixed deposit, I'm out since
Problem is,
1984.
Mr. Ghosh, Today also I recall the order of appointment of commissioner. September I appointed the commissioner. Commissioner is not doing
But
the work. None
unfortunately,
of
my
the
lord, I
matter.
was the commissioner on that.
None of the matters. It is the problem. I am not blaming
No,
the
but
commissioners. I am
it's
blaming
of course
advocate.
everyone's luck who he gets, but then the thing is we are willing to pay. I don't know how the bank is prejudiced in this. It's only in the
No, we are basically
my
prejudiced,
learned
my lord.
friend.
See, on very candidly, my lord.
No grounds is there.
Very candidly, my lord, the ground made out, my lord, in this application does not, my lord, warrant, my lord, an order to be
But
passed
no
on this.
ground is required to be made out if the
Number one.
witness is outside jurisdiction.
अनुतोष 12:30 से कब तक खाली है देखो.
But no ground is required to be made out. I don't have to show that he's sick, infirm, or anything.
23rd. अभी हम उस दिन 3 डेट फिक्स किया ना सुबह वो छोड़.
And my lord, public money is also involved over here, my lord, because this is a bank, my lord.
23rd 25 खाली है 12:30 हाँ 12:30 खाली है. So 2 days you will take.
Yes.
1 hour I will give it to you, then you will complete it to 2 days.
There's a counterclaim
So
also.
I am fixing on 23rd, 24th, and
I'll just
25th.
take instruction.
See, or when your witness will be available.
23rd of July.
June.
Yes.
So I am fixing a 23rd, 24th, and 25th June for your examination in chief. Correct. And then I will fix the cross examination. Then it will go to the July.
Let it go. That's okay. As long as it starts,
Then it will go to the. I am fixing the date here in now. Here in now, so the matter can be expedited.
Because your lordship's determination changed, we were confined only to Fridays. Therefore, my lord, we made this.
So now that's why I am making arrangement so that the other matters, which non-commercial matters, can also be taken off.
23rd is okay.
15, 16, 17, 18. 16, 17, 18 July for cross-examination. 16, 17, 18 July for cross-examination. No adjournment.
Lordship is fixing a time.
12:30 to 1:30.
12:30.
12:30 to 1:30.
1:30.
1:20, but I will give for further 10 minutes, no problem.
3 days, your lordship, I'll try.
Yes, I am giving. Sense of print for the plaintiff, sense of print for the defendant. The defendant has filed the present application, being GA 9 of 2025, praying for appointment of commissioner for examination of the plaintiff has filed the application. Defendant.
The defendant has
filed an application, being GF 9 of 2025, praying for appointment of commissioner for examination of the defendant witness, namely Sundeep SUNDEEP, Sundeep Sethia, on commission. Full stop. The counsel for the defendant has raised, counsel for the plaintiff has raised objection and submitted that the grounds on which the plaintiff and the defendant intend to examine the witness on commission is not a ground for appointment of commissioner for examination of witness on commission. Considering the above, this court find that purpose would be served if day-to-day hearing is to be fixed for examination of the witness in this court itself. Accordingly, कब क्या डेट बोला था? 18, 19, 20, 17, 18, 19, 17, 18, 16, 17, and 18 June 2025, July. No,
23rd and
23rd, 24th, and 25th.
Yes, 3
June 2025
23rd,
at 12:30 p.m. for examination in chief of the defendant's witness, namely Sundeep Sethia. Full stop. Simultaneously, again another dates are fixed on 16, 17, 18, na? 16, 17, 18 at 12:30 p.m. for cross-examination of the defendant witness.
Grateful.
The application may be disposed.
In view of the above, GA 9 of 2025 disposed of.
Well, the reply may be kept on.
Reply a copy now.
Do you? Yeah. Next.
Item number 19.
Yes.
Well, I am the plaintiff. Well, there's a defendant's application where they challenge the maintainability of the suit.
On points that I've forgotten. It happened so long
So
back.
let him recollect his points.
Barred by limitation. 1956 Act applies.
Your Lordship remembers that I know. That noting is also not required.
Yes.
As far as I recollect, he also has an additional point. Well, relying upon that, what Mitra? Rajesh Mitra versus Karnani Properties. That's his additional point, and that's the real point which I need to meet. And of course, when I ordered to rule to sub rule 3 because there was a suit
Order
before the.
23 not pressing.
Yeah. No, he says that, my lord, I had filed a suit before the City Civil Court at Calcutta, which subsequently got transferred to the Small Causes Court at Calcutta. I have withdrawn the suit and I have filed the present suit, but I have not taken leave.
That is it.
Filed of. This is one of his additional points. So, my lord, it cannot be taken up today because
3 minutes.
Yes, no, 3 minutes have left. So, my lord, I was respectfully submitting, my lord. There is an interim order subsisting on the interlocutory application filed by us, which expires today, 13th of June. Well, if that could be extended and if the matter could be kept any day convenient, your lordship.
Sense suffering for the plaintiff. Sense suffering for the defendant. Due to paucity of time, hearing could not be taken place. According cases adjourned. Counsel for the plaintiff submitted the interim order is going to counsel for the plaintiff prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended. कोई date है क्या?
Very kind of you.
Interim order is extended. Then,
The German, the Austrian mutation, the Germanation of
It's extended till 18th of July 2025. List the matter on 11th of July 2025.
Look, before your Lordship, sorry. Item number 25. This is that.
I am for the defendant one.
Yes, this is that matter, my lord, where your Lordship recalled that after the death of the employee, we figured out that he had siphoned away all the money and is now gone to the defendant. There was an interim order which is expiring today. Expiring
18th.
On the 18th.
18th of
18th of June.
Okay.
If that could be extended, my lord, we can come back on any day.
It's your lordship keeps it because your lordship has heard me for an hour. I've got just to finish my submissions on that, whether they can injunct in life insurance
18 में
policy.
18 तो खाली नहीं है ना?
The order is till 18th.
Interim order till 18th matter too.
But the 18 I cannot fix the matter.
So Lordship will extend the interim order and keep it any day whenever it's convenient for.
Yes.
Item number 25. Sensation suffering for the plaintiff, sensation suffering for the defendant. Counsel for the plaintiff submitted the interim order granted earlier is going to be expired on 18th of June 2025 and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 18th of November and July 2025 or until further order whichever is earlier. Date कुछ है उसमें 18 को खाली है. List the matter on 18th July.
On 18th.
18th July.
And your lordship extends it till the
18th July.
July.
No, your lordship keeps the matter on Fridays. I will argue it.
Friday you will get other matters fixed. है खाली है. Other matter is fixed.
But let them. I'm saying let the matter be. 18 July is the interim order. Then they are just enjoying the interim order. I'll never get a chance to vacate.
Appear on 27th of June.
I'm grateful.
Till 18 July. Let the matter appear on 27th June.
Grateful.
My lord, item number 34 of my lord's list today. My lord, the interim order is expiring on 18th. So on 18th, my lord, it may not be taken up. My lord, this was the last extension.
Who is for the other side? Nobody.
34. My lord.
My lord, in this matter, I must point out, my lord, this related to, my lord, there were defamation suits, my lord, where there were two premises, two adjoining premises, my lord.
Survey numbers.
There was an order 6 rule 17, my lord.
What has happened to that?
My lord, that has been allowed. We had taken out a civil revision application. There is a stay of all, there's an interim order, stay of all proceedings. Thank you, sir. The entire gamut of the suit has been changed, so we have taken out this civil revision application by the last order, my lord. This
So and so appearing for the plaintiff. Though the matter is listed in a day's list at serial number 34, but due to paucity of time, the matter could not be taken up for hearing. According counsel for the plaintiff, prays for extension of the time as the interim order going to be expired on 18th of June 2025. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 25th of July 2025 or until further order, whichever is earlier. Let the matter remain in the list.
My lord, a similar prayer for item number 50.
Yellow.
The interim order expires today.
50.
50, my lord.
Who is appearing? Nobody.
My lord, I have given notice, my lord. Mr. Rajesh Upadhyay was appearing.
No, it is not here. So appearing for the plaintiff. Though the matter is listed as item number
50, my lord.
50, but the matter could not be taken up for hearing due to paucity of time. But learned counsel for the plaintiff submits that the interim order is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order is extended till 25th of July 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Most grateful, my lord.
I'm really sorry, but the matter was mentioned in the morning. Your lordship said to mention it.
Which one?
If item 36, if it is not taken up,
yes.
My lord, 2 months after the 2 years after the written statement, a section 8 application was filed, and they have stalled our suit. But we gave them notice, they didn't appear. Now they are, for the third time, they're saying, please communicate with the client directly. The advocate is saying. So your lordship keeps it any day at 1 o'clock. Also, we'll give notice to them.
Item number 36.
36, my lord.
You are for the plaintiff.
I am for the plaintiff. My application is there for examining my witness, and they have taken out an application under section 8, even though they had filed their written statement long time. 2 years. 2 years ago.
36. Counsel for the plaintiff submits it, and though the matter is listed as to be listed.
We gave them notice that
36, but the matter could not be taken up for the hearing. According, learned counsel for the plaintiff has mentioned the matter and submit that the case is at the stage of witness action.
No, it's for, they've taken out an application under section 8 of the Arbitration Act 2 years after they filed their written statement.
The defendants have filed an application.
Yes, and my witness is ready.
Of the Arbitration and Cancellation Act after the period of 2 years. But the plaintiff is ready to examine the witness.
Yes.
And he prays for fixing the matter on a specific date.
And these applications, 5 minutes it will take.
GA
2 to 4.
In view of the submission made by the counsel for the plaintiff, kya koi date hai?
Any day at 1 o'clock also, we'll give them notice directly. The advocate is now.
12:30 नहीं है? 12 PM क्या है? 12 to 12:30 ये कब रखे? 1 बजे. ठीक है. On 27th June at 1 PM.
I'm very.
I permitted to mention item number 24. Probate was granted in favor of me. Thereafter, the daughter-in-law filed a revocation application, and the revocation application was dismissed by your lordship. Thereafter, again they filed a recalling application. I am 79 years old really. Kindly fix the matter any day so that
it will come, because now we are reached till 2020. Today कितना minute? 22 हो गया ना? Yes, it will reach on the next date. It will be up.
Next Friday, lordship.
Next Friday.
My lord, may I be permitted?
Kindly take the top, lordship.
Yes, it will come as.
Lordship.
Lord, may I be permitted to mention item number 20? My lord, this is the Calcutta Swimming Club matter. My lord, the petitioner has preferred an appeal, which is being heard. My lord, I was praying let the time to file the affidavit in opposition be extended by 2 weeks, my lord.
Opposition of?
My lord, to the petition, my lord.
Lordship, one thing, Lordship, Lordship had been hearing this matter on the point of ad interim relief.
Yes.
Lordship has already passed a judgment on 20th of March 2025, directing to file affidavits. Lordship is pleased to keep it part third. It's my duty to point out, that's why, Lordship.
That is identity my pass. Then why it is here listed here?
because it
क्यों पाठक क्यों है? Interim order तो हो गया.
Kept the injunction application part of the
Interim injunction already disposed, ad interim disposed of.
Yes.
So there is no question of part heard. क्यों part heard आया? Okay, we'll see.